Christy Browning, also known as Christy Canterbury.
Yes.
This case number is 18-13-18, 19-171.
Your Honor, she did successfully complete her BP inpatient, and now she is with Huntington Transitional Living.
Okay, good urine screens too. And looks like you're compliant with your treatment program. Can we get a copy of that? Is this your caseworker, Samantha Whittington?
Yes.
Okay. Just get a copy of that, place it in the file. Can you make any payment on your fines today?
Not today.
Are you working yet?
No.
Are you looking for a job yet? Okay. You can do community service toward your fine, so if you can't pay, at some point, well, you can start now. Any day you do community service, you get $50 credit toward your fine or court costs.
Okay.
I'm going to set your next review hearing for February 20th. Now, that's going to be a Tuesday because the 19th is President's Day, so the court will be closed. Usually we have court Mondays and Fridays, but since it's a holiday on that Monday, court will be on a Tuesday, February 20th at 9 a.m. You're doing good. Keep doing what you're doing.
Thank you.
You're welcome. You're welcome. Savannah Krager. Savannah Krager is 19741, 19214. She still has fines, court costs, and community service complete. So there'll be a warrant issued for failure to appear today. Angela DeHart.
Yes.
23681.
Your Honor, Angela's at Bethesda. There's her report. She's only been in treatment about 30 days, but she's compliant and doing well.
Okay, so it's a good report. And this is she's outpatient?
No, she's inpatient.
Okay. Okay, anything you want to tell me, Angela? Or?
No.
Okay.
Thank you. I'll tell you that. Thank you.
Well, thank you for doing well and taking this seriously.
I appreciate it.
You're just getting started, and it looks like you've got a good start. So
I appreciate that.
we'll see you back in about a month. Let's make it February 12th.
Thank you.
Will be your next hearing at 9 o'clock. That's a Monday.
Thank you,
Okay,
sir.
good job. Sebastian Evans.
Your Honor.
23-349. Okay, you've got fines and court costs, and you're also got issues you're dealing with in common police court.
What is it?
Aren't you in the common police court also in Ironton? Do you have court there?
I haven't had court there. I had it one time. They didn't give me another date, I don't believe.
Okay,
That was family court, though.
I'm sorry, I didn't understand.
I believe that was for family court.
Okay,
It all tied in with this case.
is that, well, in your judgment entry, it says subject to orders of common pleas court. Is that over now, or what's going on in common pleas?
Was I supposed to be there?
Yeah, I mean.
Was that today?
No, I don't know about that.
Okay.
Did you have a case in common pleas court?
Yeah, in Ironton.
Okay, that's what I'm wanting to know.
Yeah,
What happened with that?
They put a protection order on the mother of my child.
Okay.
I haven't talked to her since then, but they told me that I had to come here one more time to talk to you about my probation and everything.
Yeah, you're on probation here.
Yeah.
In this,
I haven't, I totally forgot that I had fees here, so I will be paying something today after I'm done talking to you.
the mother, this is the mother of your child or children, Savannah?
Yes.
Okay. What's going on there?
Just haven't, I don't know, I haven't spoken to her since that day, so.
You're getting no visitation with the child?
No, I haven't. They want me to do a paternity test, and I haven't had the money to do it yet.
Okay.
They want me to get a lawyer.
They haven't appointed you a lawyer?
No. When I went to court, I believe it was the state, or whoever else was in the courthouse, or the courtroom with us, he told me that I would have to get a lawyer to file for a paternity test.
Okay. Let's get Mr. Steyer in here. He was your attorney on this case. Mr. Steyer, I'm going to reappoint you on, this is Sebastian Evans. If you want the court's file, I'm sure you don't have your file with you.
I don't.
He had some case going on in common pleas. It might just be over custody and child support. I'm not sure, but there was a reference made to it in this court's judgment entry on domestic violence case, and he seems pretty confused and unclear as to what's going on in common pleas. So if you would, I'd like for you to talk to him, do a little investigation. Let's call it back up
Okay.
after you've done that. So the case will be recalled later in the docket.
I'm going to have you wait for a couple minutes. I've got somebody who's going to come up earlier. The arraignment will be in here for that. She said it'll be about 10 minutes probably.
Olivia Gilpin.
Yes, sir.
Olivia Gilpin is 23-1291, 23-591, 592, and she's at Bethesda also.
Yes, Your Honor. She's also an inpatient, also doing well and compliant right now.
Okay. Compliant, but it looks like from the report that you still have some stuff to work on, all right?
Always got stuff to work on.
Okay, that's true. The key is realizing that. We all have stuff to work on. Some people don't realize they got stuff they need to work on, so.
Yeah.
Self-awareness is really important, first step, so. Okay, and you have some community service and fines to pay too.
Yeah.
How are we gonna take care of those?
I don't know, community service.
Your Honor, I will say that she also has community service through common pleas court, and she's
Yeah.
been going up there and doing it every week.
All right, so at some point, once that cleared, then she can start doing some
Absolutely.
community service on her cases here also. Okay, February 12th will be your next hearing, 9 o'clock. Joseph Graham.
Your Honor, he doesn't appear to be here, but he is currently compliant with outpatient. I already gave a letter up for him. It was the first one I sent up.
Okay.
I think you thought it was Christie's there at first.
All right, I don't think I got that. You have an extra copy?
Yeah.
Probably went in the wrong column.
He's attended all of his appointments and his drug screens are compliant as well, so I'll reach out to see if we can get a hold of him to see where he's at.
Okay. What I'll do, I'm just going to go ahead, since he is compliant with his treatment, I'm going to go ahead and continue it, give you another date that you can pass on to him. And then if he doesn't appear at that one, then I'm going to issue a warrant for his arrest.
All right.
So let's look at the calendar and see what would be good. Will he be in this next week? Does he have services?
Yeah, once a week.
Okay. You know when the next date he would be in?
I can't see it right now, I'm not sure.
Okay, well then, I was just gonna make it the 19th. That might be too soon. Let's do it the 29th. January 29th will be his next hearing. If he doesn't appear then, I'll issue a warrant for his arrest.
All right. Thank you, Your Honor.
You're welcome.
Elizabeth Hatton, Austin Pritchard, Cornell Rogers, Michael Rowe, James C. Thompson, Adrian Waldron Bishop, Sarah A. Woods.
Elizabeth Hatton, 1539.75, and she actually has a bond up with Mr. Sowers, so it should have been on the, actually should have been on the sentencing docket, but she was notified to be here today, so I'm going to issue a warrant for her for failure to appear, and I'll notify Mr. Sowers by sending him a screenshot of the bond. And we'll set the bond forfeiture hearing January 29th. So warrant should be issued on this today. Austin Pritchard.
Yes, sir.
18, 1233, 1234, and 3525. Okay, you paid off your OBI. You still have
Restitution.
restitution
Yeah.
to pay too. So are you making a payment today?
Yeah, 40.
40?
Yep.
Okay. See the clerk to make your payment, and I'll set your next hearing for February 12th. 9 o'clock.
Thank you, sir.
You are. Cornell Rogers, 23205. Cornell Rogers has been called for. Has failed to appear, so there'll be a warrant issued. And it looks like he may be on probation in Cabell County also, and there's a, I think it's the probation officer listed in the file, so might get in touch with that person, so let them know that he failed to appear for a hearing. Okay, Michael Rowe, I'm going to pass. He's going to appear by teleconference from the Gallia County Jail where he's housed on some offense up there, and he's not on the teleconference yet. They were doing hearings from the common police court, so they had the teleconference equipment tied up, but he will appear later today. James Thompson, 23306. He's
Your Honor, he
an
completed
RRS.
treatment.
I'm sorry?
He completed treatment December 1st.
Okay. Can you, I have a letter, but I don't think the letter I have it's not a completion letter. Can you give me a completion letter?
Yes, sir.
All right, subject to that, I'm going to take Mr. Nguyen's word for it. You are completed, sir. I'm not going to set any more review hearings for you. So you paid your fines and court costs, and you're ordered to complete treatment, and he says you've done that, so you are completed.
Thank you.
Congratulations.
Thank you, Your Honor.
Adrian Waldron Bishop, 23174.
Your Honor, she is compliant. There have been a few missed appointments because of sickness with her, and the therapists have been sick a few times, but other than that, she is compliant.
Okay. And things are not completed, she's still working on some issues.
Correct.
All right. Okay, so that's all you gotta do to finish up. You've paid you just had court costs to pay, and you paid those, so. Do you have an idea as to when she will?
No, I'll ask her therapist once she gets back in and see where we're at with that.
Okay, I'm gonna go, since she is compliant, she's paid everything, I'm gonna go a couple months out instead of
Okay.
a hearing, follow-up review, and then if we get a completion letter, that'll finish you up. You won't have to come back anymore after that. So let's make it March the 11th, so right at 2 months. March 11th will be your next hearing, and that may complete it, 9 a.m.
Thank you.
You're welcome.
Thank you.
You're welcome. Sarah Woods. Sarah Woods, 22-326 and 21-686. She's at Mended Reeds, or has been. Is there anybody here from Mended Reeds today? I have a reporter. It looks like she was, for the reporting period, compliant with her counseling. So I don't know why she's not here today. She still has things to do. She has community service and fines and court costs to complete, but she's compliant with her treatment. So I'll continue it to the 19th and notify Mended Reeds to tell her she needs to get in here then, or there'll be a warrant issue. So January 19th at 9 a.m. Okay, that finishes the reviews. If there's anyone out in the lobby that has an arraignment, they need to come in now. So we'll start the arraignment hearings. Okay, so arraignments are what the hearings are called on a first appearance in court on a criminal matter. The purpose of an arraignment is to tell you what the charges are. I don't make the charging decisions, that's up to the prosecutor. So the charge may not be true, it may be totally false, but you need to understand it. You don't have to agree with it. So when your name is called, come up to the table to your right, just like the previous folks did. Stand there, and I'm going to go over the charge with you. I'll tell you what the charge is, what the possible penalties for it are, and then we'll talk about bond and lawyers and that sort of thing. You have a right to remain silent. You don't have to say anything. If you choose to make statements, though, what you say is on the record. You can see there's all kinds of equipment around here. We now have like 3 systems that are recording what goes on here. So if you know, I've had this happen. People get up and say, yes, I did, or something like that, where you admit what you are charged with. That's on the record, and it can be used against us. You don't have to say anything, but if you do say something, it can be used. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state prove any charge against you beyond a reasonable doubt. Those are the rights that all defendants have. If you choose to enter a guilty plea or a no contest plea, you're waiving those rights. You should not do that if you don't understand the proceedings, if you want to talk to a lawyer, if you want a trial, or if you don't know what to do. You should enter a not guilty plea because that will preserve all those rights that you have. If you enter a guilty plea or a no contest plea, then usually I'm going to proceed to sentencing today, and you waive those rights that you have to make the state prove the charge against you. So don't do that if you don't understand what's going on. Call the first case.
State of Ohio versus Ashley Sammons, case number CRB 23751.
Mr. Steyer, you're going to be representing the Salmons?
I am, Your Honor. I've been retained on this case. Ms. Sammons would waive reading of the charges and enter a not guilty plea at this time.
All right, not guilty plea is entered. Has she posted any kind of bond?
No, this was she was brought in on,
Looks like a
summons on this, Your Honor.
She can sign a $1,000 signature bond then?
Yeah, sign here right there.
I'm setting things the 19th or after, although I'd like to keep the 26th clear.
19th of this month, Your Honor?
Yes.
I'm going to file discovery in this matter, so we could do this. You said you're keeping 26th clear? Does Monday or
26th,
Friday
right.
matter for you? I don't
That's
know.
Mr.
That's
Mayor.
the question. That'd make a difference. 29th work, Your Honor?
Yes. January 29th will be the next hearing. It'll be a pretrial at 10 a.m.
January 29th, 10 a.m.
Not guilty plea is entered for her.
That's what I thought. I think I got their protection.
State of Ohio versus Daniel
Thank
L.
you.
Turner, case number CRB 23732 and TRD 1562 A and B. Daniel L. Turner.
Daniel Turner has been called for. He has a warrant outstanding from an old case already. And he did not appear today. So I'll issue a warrant on the new case. So you'll have 2 warrants, I guess. So a bench warrant is issued for failure to appear for arraignment.
I'll do it at the pretrial.
State of Ohio versus Seth Coleman, case number CRB 23748. Seth Coleman. Not checking in.
Okay, Seth Coleman was personally served by the sheriff's office with a summons to appear today. And has failed to appear, so now there'll be a warrant issued since he failed to appear.
State of Ohio versus Brian McClellan, case number TRD 182552 A through C, TRD 16200, TRD 161007 A and B, TRD 143549 A and B, TRD 101638 A and B.
All right, Mr. McClellan, you had a review hearing on January the 5th, and it's last you missed that hearing. So that was a week ago. Correct. Do you admit or deny that?
Yes, I admit it.
Do you have an explanation for this?
Just car trouble, I just got it fixed Wednesday.
Okay. Do you have, as I recall, I think all you have to do is pay fines. Do you have a payment on your fines today?
Yeah, I made a payment.
You've already paid?
Yeah.
Yeah, $20. All right, February 12th will be your next hearing, 9 o'clock.
Okay, thank you.
You're welcome.
State of Ohio recalls Michael Rowe, case number CRB 23-4.
All right, Mr. Rowe, can you hear me?
Yes, sir. Yes, sir.
All right, this is arraignment on a review hearing. Well, actually, it's was set for a review today. So this is a review hearing today. I understand you're in Gowdy County Jail now.
Yes, sir.
Do you have a new charge there?
Yeah, no, not.
Okay.
And on the registry form, I guess I was getting the mixed up papers, so they wanted me to have the actual manual copy, and I just said I gotta come down there. My setback on the first one, they said something about you or someone has to sign a piece of paper so I can get the copy, but they want a hard copy of it. Like I said, I was trying to get them to back it out, and they said they would not accept the back copy.
Okay.
And I was just wanting to know if it's okay if I'm able to come get that.
Yes, there is a registration form in your file, and it's showing an expected residence address to be 303 Rocky Run Road, Gal Cliffs, Ohio. Is that correct?
And sir, it's not that one. Yeah, you're right. And I'm going to drive today because they said something about they might award me after I get things like that. And if it's not too late and if y'all still listen, I want to try to get my setback to get you down there so I can hurry up and get it done and over, if that's all right.
So, as I understand, you told me you will not be living at 303 Rocky Run Road. Is that correct?
No, I ain't.
Oh, so that is the correct address.
Yes. The main document, they ain't got me. That he said, I'm looking at, that's what I said.
Okay, there is a form in your file ready for you to sign, and you'll be residing there with your stepfather. Is that correct?
Yeah, they'll be the one to bring me up there.
Okay. In addition to that, that form needs to be signed by you. You have fines and court costs to pay too. You understand that?
Yes, sir.
So you have not appeared in court in Gowdy County yet?
Yeah, it's pre-trial. I got it 24.
Okay. I'm going to set your next hearing. I'll go out another month. So to make it easier for you to review.
It'll be done now, first thing I'll find, stuff like that.
All right. Exactly 1 month from today, so that's February the 12th. That's going to be your next hearing. And I'll set it at 9 a.m.
Yes, sir.
All right. You can get here, as long as you get here before 4 o'clock. The court closes at 4.
And then if I can, I don't know how they work on the release because they said it takes time for the paperwork to go through before they can log it. Today, I promise it will be Monday, and I will be down there to do what I got there.
Well, the court ordinarily the court would be open on Monday, but Monday is a holiday. It's Martin Luther King Jr. Day, so court will not be open on the 15th. It will be open on the 16th. So you can come any day that the court's open, which is Monday through Friday, except holidays.
Yes, sir.
Okay. All right, that's all.
Okay.
State of Ohio versus Brittany Nicole Kraft, Case number TRD 163493.
All right, and ma'am, you are Brittany Kraft?
Yes.
This is an old case, but it looks like there's been a failure to appear on it previously. Well, actually, I think you did come in and pled no contest and were given a continuance for a sentencing hearing. It looks like August 26th of 2016, you appeared, pled no contest. It was continued till September 26th for sentencing, and due to the nature of the charge, I'd say it was to give you a chance to try to get it straightened out, and so as you didn't show up for the hearing. Do you understand the allegation against you?
Yes.
Do you admit or deny you failed to appear for your hearing?
I admit I was not here because we moved to Florida.
Okay, so apparently you moved back because it looks like you
Yes,
got
we
arrested
just-
on the warrant
Recently moved back.
and posted a bond. Do you have a driver's license now?
No.
Okay, do you want to get a driver's license?
Yes.
Do you know what you will need to do to get a driver's license?
I do not.
At the time, back in 2016, you had you had two suspensions from Hanging Rock Mayor's Court that were indefinite. That means that they had a start date but no end date. So do you know if those have been resolved?
I do not know.
Have you, here's what you're going to need to do. I mean, I'll give you some time. You've got a bond up now, so that means if I set a new date for you and you don't show up, your bail bond's just going to come and get you. It's not going to go, years before you get picked up, because the sheriff is not going to go look for somebody on a driving or suspension. But the bail bondsman will, because he doesn't want to pay the money into the court. So you got to get here, and I'm all about helping people or encouraging them to get their driver's license, because you're living here in Lawrence County now?
Yes.
Well, as I think you know, there's no subway system or great public transportation, so you need your driver's license.
Yes.
So let's get that done. What you need to do is contact the B&B, and you can go to the local agencies now. Are you living in Ironton?
At Colgrove.
Colgrove, okay. Well, the closest one for you would be the one in Ironton. They're supposed to help you now. They probably don't like me telling people that, because they used to. They didn't have to help you with your license issue, but you're supposed to be able to go in there now, and they'll pull it up and walk you through what you need to do to get reinstated. So that's where I would start if I were you. Go to the local B&B, give them your identification information, let them pull it up. It looks like if things haven't changed since the last time, you got some tickets or something in Hanging Rock that you didn't take care of. So you're going to have to get them to lift their suspensions, and that probably means paying them some money. I would say. I think I'd go out on a limb and say that's what it's about. But you need to get that squared away if you want to. You want to try to do that, or you want me to just go ahead and sentence you based on
I would
what?
like to try.
Okay. Let's go out about a month then to get that taken care of. Are you working now?
No, because I don't have a license to get anywhere.
Okay. Makes sense. So it doesn't matter if it's a Monday or a Friday when you come back to court?
No.
Let's make it the 16th of February. That's going to be a Friday. It's a little over a month. So February the 16th at 10 o'clock, I'll set it as a sentencing hearing. Because you'd already pled, you agree, you pled no contest way back then, correct? So we're not going to fight about whether you did or didn't do it. It's just about what should be the penalty for it. And of course, I'm going to give you less of a penalty if you get your license back. Do you have any questions?
Do I just here? Just the.
Come right back here, 10 o'clock on February the 16th. And go to the B&B. They control your license, find out what they want you to do to get up. And probably by this time, you're going to have to retest, I would say. And start working on it immediately. Don't wait until February the 15th to start working on it. Start working on it immediately. Any questions? Okay, that's all.
State of Ohio versus Walker L. Panel, case number CRB 2423.
All right, your Walker panel.
Yes, Your Honor.
Mr. Panel, the state's alleging that at Fayette Township, January the 10th of this year, you purposely deprived Walmart's property without their consent. That's a theft offense. The maximum penalty for that is 6 months in jail and a $1,000 fine. Do you understand the charge?
Yes, Your Honor.
Do you understand your rights?
Yes, Your Honor.
How do you plead to the charge?
Not guilty, Your Honor.
Do you wish to have a lawyer appointed?
I think so, Your Honor.
Okay. Are you working?
No, sir, I'm a student.
You have no income?
No, Your Honor.
All right, I'll appoint Mr. Smith, Roger Smith, to represent you. Enter a not guilty plea for you. And I'm going to let you sign a $1,000 signature bond. What that means is you're just signing a piece of paper that's kind of like an IOU. You're saying, I'll owe $1,000 if I don't show up, but I'm going to show up when I'm ordered to. So then you don't have to post any money. So just come to court as you're ordered, and you don't have to post any money. You're guaranteeing your own appearance. What's your schedule, Mr. Smith, in the coming weeks?
I'm here January 19th, 22nd, 26th, then the first week of February, I'm here the 2nd, 5th, or 9th.
The 19th is one of the least crowded days coming up.
I can do that, that's a week from today.
Yeah. January 19th will be the next hearing. It'll be a pretrial at 10 a.m.
Thank you, Judge.
You're welcome.
State of Ohio versus Brooklyn Weddington, case number CRB 2422.
Ma'am, are you Brooklyn Whittington?
Yes, sir.
Ms. Whittington, it's alleged that on January the 9th in Perry Township, you knowingly caused or tried to cause physical harm to Charles Ethan Scott.
Yes, sir.
And that Charles is either a member of your family or lives in your household. So that's why it's called a domestic violence charge. The maximum penalty is 6 months in jail and a $1,000 fine. Do you understand this charge?
Yes.
Do you understand the rights you have?
Yes, Your Honor.
How do you plead to this charge?
Guilty, Your Honor.
Guilty means you're admitting it's true, you waive your right to have a trial, to have a lawyer, if you enter a guilty plea. Do you understand that?
Yes, Your Honor.
Is Charles here today?
No, Your Honor.
Sorry. One thing you need to understand that's a little different than on these charges than others, well, there's some like this, but a lot aren't. This is kind of progressive in the sense that if you get a conviction for domestic violence and then you get charged with the same offense again, that escalates it to a higher level offense. So this goes on your record and stays there and can cause you to have more legal consequences down the road if you get charged again. Do you understand that?
Yes, sir.
So this is a pretty serious charge. If you got an additional charge, it would be considered a felony. And felonies mean you can go to prison over that. So it's going to be up to you, but this is probably the kind of charge that you maybe should talk to a lawyer about. Do you have the money to hire a lawyer?
No.
Are you working?
No.
Do you have no income?
No.
Okay, I can appoint a lawyer for you. And I think that would be a good idea.
Yes, sir.
All right, Mr. Scott, I'm going to go ahead and appoint you
Thank you, Judge.
to represent Ms. Whittington.
Judge Wade, I will ask to withdraw that plea of guilty and her plea of not guilty at this time.
That'll be allowed since it was uncounseled. Not guilty plea is entered. Is there a protection order request to?
Your Honor, we would try to reach the alleged victim in this if the court wanted to call this back
Let's
up.
let Mr. Scott let you talk to Ms. Whittington, let the state try to get a hold of the complaining party, and then we'll discuss bond after those two things happen.
Absolutely. Thank you, Judge.
You are.
State of Ohio, ready for the jail, Your Honor.
Okay.
State of Ohio versus Charles Carter, case number TRD 152506. Johnny Maynard is on deck.
All right, sir, are you Charles Carter?
Yes, sir.
Mr. Carter, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. It's alleged that you have a warrant here from an old case from 2015. The case number is 152506. It was a driving under suspension.
Yes, sir.
It looks like you failed to appear for a review hearing. It's alleged to have been on August the 12th of 2020 and got a warrant issued that's been outstanding since August 20th of 20.
Yes, sir.
Do you understand that allegation?
Yes, sir.
How do you plead to it? Do you admit or deny that you missed your hearing?
I admit it, yes, sir.
Do you have an explanation for missing the hearing?
There was so much going on. I moved twice and recovered and everything, and there was this expectation, and I tried to figure things out, and I moved so much, and it just, the mess. I don't know, sorry.
How did you get arrested? What caused you to get arrested?
My girlfriend, I split up. I was trying to get everything out of the house. Her mother and father had put their I guess mother and father got their over, and they both called officers, called officers, and had them show the house that I was filming, and I think that I had.
Is there charges that are going to be filed on that?
No.
Where are you
I
living?
don't know if my mother is there. She was supposed to be there. She is going to, I don't know if we talked to you guys or not. She's going to pay everything off on the 24th. I'm pretty sure she said. She just paid off everything that was here in Arraignment 2 this morning.
Okay, I see a lady shaking her head in the front row to the left. Ma'am, are you this gentleman's mother?
Yes, sir, I am.
Yes, sir.
What is your name, ma'am?
My name is Janet Carter.
Janet Carter. Where do you live, ma'am?
I live in South Charleston, Ohio, up near Columbus.
Okay. I didn't know there was a South Charleston, Ohio, but they probably don't know there's a Chesapeake, Ohio.
I paid off his fines in Ironton this morning. I can pay on his fines here now. I can't pay it completely.
Well, you know, it's not really your responsibility to pay his fine.
I understand that, but since 2020, he's gone on disability for having seizures. He also has a disease called Raynaud's disease.
Yeah, I didn't understand the last thing you said.
Raynaud's disease.
Okay, I've never
He
heard
has
of it.
that as well.
Is he living with you?
No, he's not. He was living with this girl that he was with.
Okay, oh yeah, you told me about that. Well, he's got community service to do. You don't want to do that for him, do you?
Oh, Lord, no. Sir, I work for the state of Ohio prison system.
Oh, you're still working?
Kind of ironic, yes, sir, I am.
Well, I'd rather he pays this rather than you pay it.
Well, I understand that, but he's on disability,
I'm
and
going to pay her back.
with the bills that he's paid, he just spent his disability check paid bills at the house that he's living with this girl at, so he didn't have the cash flow.
Do you approve of this girl?
Not now, I don't.
Okay. I mean, how old is Charles?
What are you?
Thank you.
It's kind of old for a mom to be take care of this family cost.
I asked her not to, honestly, when I called her from here, I asked her not to.
Yeah, I don't want you to either. He's not going, maybe we're too late for this, but he's not going to learn anything if you keep bailing him out.
Well, this is the first time I've attempted to bail him out. I have never bailed him out before, which is
Well,
why.
you paid for another court, you said, right?
Well, the Ironton one, yes.
Yeah.
Yeah.
All right, Charles, when you get out of here, where are you going to be living?
With my sister, yeah.
So the girlfriend's out, now you're not going to be living with her.
Sorry?
You're not going to be living with the girlfriend anymore.
No, sir, no, sir.
And she's the one who lives in Lawrence County.
Yes, sir.
And how long you been in jail?
Last night.
Yeah.
8 o'clock, I think it was.
Okay. Well, this is the second time this has happened. This isn't the first time this has happened, where you missed the hearing. So, I'm gonna sentence you to a couple days in jail, and then I'll release you. So, 48 hours in jail, then he can be released, and then I'll give you a new review hearing date, and I'm gonna direct the clerk not to accept your money. Your money's not good here. You need the money for yourself. Unless you tell me, oh, I've got a trust fund, Judge, you don't have to worry, I got oodles of money.
No,
That's
sir,
not the
I've
case,
been
is
a
it?
worker all
I
my
didn't think
life.
so.
I don't have a trust fund.
So you keep your money, let's make Charles pay for this. Charles, your next hearing here at the court is February the 12th at 9 a.m. If you don't show up, you get a warrant. You understand that?
Yes, sir. February 12th, just Monday?
That is a Monday.
Okay, okay.
You know where the court is, right? You've been there
Yes,
before?
sir.
Okay. You'll get out after you spend a couple days in jail for contempt for not coming before or paying this off a long time ago. And we'll see you February the 12th, or, you know, you can do community service. Are you able to do community service? You got to.
Yes, but that's what I was going to ask her. I have to do, you know, I can't do the weed eater, I can't, you know, I can't do that kind of stuff with my seizures and my radons and.
We've got light duty community service we can give you.
That's what I really said, that's my biggest question I was going to ask, thank you.
Yeah, we'll figure out something for you to do. It's not too hard. You won't be scraping grease from under the mill, so it won't be that bad.
Yes, sir.
Excuse me, Judge.
Yes,
Does he have
ma'am.
to do his 48 hours while he's in there now?
Yes, ma'am.
We had arranged with this girl to get all his personal property tomorrow.
Yeah,
She let me
well,
do it today, but I told her I couldn't do it today.
yeah, well, sorry. He's gonna have to make other arrangements.
So when will the 48 hours be completed?
48 hours or whenever he went in the jail.
Hey, been 8 o'clock?
Thursday, tomorrow night.
So 8 o'clock that tomorrow night?
All right, that's all.
Is that 9 a.m. on the 12th, sir?
Yes, ma'am. You're gonna make sure he gets the court?
Absolutely.
Okay.
State of Ohio versus Johnny L. Maynard, case number TRC 13976, A, B, and C. Brandon McClaskey is on deck.
All right, sir, are you Johnny L. Maynard?
Yes.
All right, Mr. Maynard, it's alleged that you missed a hearing and you beat the last record. This is December 2nd, 2013, and it was on an OVI conviction. And since you didn't appear, you got a warrant issued, and it looks like you got arrested on the warrant.
Yes.
Do you admit or deny you missed the hearing in this court in 2013?
I was under the impression that, like, all my fines and everything was paid off because I did my community service and everything tested.
Okay, I'll take that as a not guilty plea. Do you want a lawyer appointed to represent you?
No. I don't think I need one.
Well, I think you do.
All right, I'll
All right, and he had Paul Nipp as his lawyer back in the day. He's now the county auditor, so I can't appoint Mr. Nipp. He's no longer practicing, to the best of my knowledge. Mr. Morford, I'll appoint you to represent Mr. Maynard.
Thank you, Your Honor.
What I'm showing in the record is he's correct. He did do his community service, but he never paid anything on his fines and court costs.
That's what,
Yeah, you should ask your lawyer once you get to talk with him.
I'll call you here in a minute soon.
Part of this was restitution. There was restitution of $325 ordered to Carissa Weaver and $500 restitution to Charles and Stacy Miller. And there was also some fines, court costs on a driving under suspension and a clear distance ahead. You can have the court's file. I'm going to have Mr. Morford call down and talk to you. Your bond will be $3,000 cash or surety.
all right.
And your next hearing will be January the 19th.
All right.
And it'll be a pretrial on review at 10 o'clock. So if the jailer can hold him out, his lawyer's going to call down and talk to him. You're on.
State of Ohio versus Brandon McClaskey, case number CRD 22565, and Sean Vance is on deck.
Sir, are you Brandon McClaskey?
Yeah.
I'm Judge Capper at the Lawrence County Municipal Court. It's alleged that you missed a hearing October 23rd of 2023 on an assault conviction, and therefore a warrant was issued for your arrest, and it looks like you got picked up on the warrant.
Yeah.
Do you understand the charge against you?
What is it?
The charge is that you failed to appear for a review hearing in October of 2023 as ordered by the court. Do you understand that?
Yeah.
How do you plead to that charge?
Not guilty.
You want a lawyer appointed to represent you?
Yep.
Do you have a job?
No.
I'll put Mr. Stratton. Let's have Mr. Stratton come in the courtroom. Yeah, Mr. Stratton, please.
He's coming.
Sorry, Your Honor.
No problem. I'm appointing you to represent this gentleman, whose name is Brandon McClaskey.
Okay.
He was represented by Mr. Thompson previously. This is a alleged failure to appear for a review hearing back in October 23rd of this year. It was an assault conviction. He was ordered to pay court costs and pay some restitution for a phone and a broken windshield. And nothing's been paid, and he didn't appear. So he pled not guilty to that, so I'm appointing you to represent him.
Okay.
I'll set bond now at $5,000 cash or surety.
Okay. No new charges.
No new charges. Set his next hearing for January the 19th.
Yes, that's good.
Pre-trial on review. assuming you're going to want to talk to him today by phone, or?
Yeah, I'm gonna speak to him. Will the court consider revisiting that cash and surety today?
Yes.
Okay.
You bring it. I'll consider anything you bring up before the court, so
Yeah, I didn't know if you would recall.
we'll recall it. Okay, your lawyer's going to talk to you today, Mr. McClaskey.
All right.
State of Ohio versus Sean Vance, case number CRA 2421. Johnny Maynard on deck.
Sean Vance, 2421. And sir, you are Sean Vance?
Yes, sir.
Okay, I've got a warrant allegedly filed in this court from the state of Indiana, Elkhart, Indiana, alleging that they have a warrant out for a Sean Michael Vance with the date of birth of October 27 on felony non-support of a dependent child. And they're asking that you be extradited to that court and ask for a $78,000 bond. So you have a right to have what's called an extradition hearing. An extradition hearing is a hearing held in the jurisdiction where you're found to determine if the warrant from another jurisdiction is valid, and if there's good reason to make you go to that other jurisdiction to face the charges. It would not be, I'm not going to have a trial on whether you violated Indiana law, but I'll look at the extradition, whether they have a valid reason to bring you to their court. And you have a right to have an attorney in the extradition hearing, to have one appointed for you if you can't afford one. You can waive extradition, which just means you're not agreeing that you did what Indiana alleges, but that you agree that you'll go to Indiana voluntarily to face these charges. How do you?
Yeah, I will voluntarily go to Indiana to face the charges.
Okay, so you don't want an extradition hearing here?
No.
All right, so we'll send down a waiver of extradition form for you to sign.
Okay.
The Indiana court asked for a $78,000. It's a kind of an odd number. I don't know if that's the back due child support. I suspect maybe it is. So I'm going to set your bond as they requested, the $78,000 cash or surety. Do you think you can post that bond?
Probably not, no.
Okay, it's a pretty high bond. So I'm going to give them at least initially a week to come fetch you to their jurisdiction. If they ask for more time and have a good reason, I might extend it. But at this point, I'm going to set your next hearing in this court on January the 19th.
Okay.
At 10 o'clock. And I'm going to direct that the jail let Elkhart, Indiana authorities, and I'm assuming it's the sheriff out there, know that they've got till January the 19th at 8 a.m. to pick you up. So hopefully you'll already be on your way back home to Indiana. I don't know if that is your home, but there was a movie by the name with Mickey Rooney in it. I'm pretty showing my age. Back
Famous
home.
song, too.
Yeah. So, we're going to send down a form for you to sign that waives your right to an extradition hearing.
Okay.
I'll see you again next Friday at 10 a.m. or thereabouts if you haven't been picked up by Indiana. If you have been picked up, of course I won't see you, and this case will be dismissed. So Indiana should be notified. They've got a week to come get him to bring him back to their jurisdiction, at least initially. And the clerk here is to fax down the extradition form.
Okay.
Any questions, sir?
No, sir.
Jailer Johnny Maynard and Brandon McClaskey will be recalled shortly. Mr. Morford hasn't talked to John Mayer yet.
Okay, Mr. Mayor, we don't need you yet back because your lawyer hasn't talked to you, so we'll see you after you talk to your lawyer. So we don't need this gentleman on the screen. Let's get the next one. Who's next?
Well, I doubt if they've talked to him.
Okay, so we'll come back to the jail. We're apparently early on getting back to the jail.
You've got a pre-trial, you probably out in the courtroom right now.
State of Ohio recalls Sebastian Evans, case number CRB 23349, A and B. Mr. Stiers.
All right, this is, I appointed Mr. Steyer, actually reappointed him. He had on this case originally. There's some issues about a case in common pleas that was noted in the court's judgment here. And I just wanted to make sure everything's on the right page.
Your Honor, while we were out, Mr. Evans made a $40 payment toward his fines and costs as well.
I see that, that's good.
And then, I called over to juvenile and probate court. They were able to provide me with a copy of the protection order. What happened is the alleged victim in this matter had filed for a CPO in juvenile probate court. I guess she initially filed seeking a CPO protecting her and their common child. It was granted as to her, but not granted as to the child. And it would be subject to any further custody allocation that took place. Mr. Evans advised that there's not been any further proceedings seeking custody. I wasn't able to confirm that with juvenile and probate court because that's protected information they couldn't give me unless I entered an appearance in an existing case there, which I wasn't able to do. But I have no reason to doubt that nothing else has happened, but we do have this protective order.
All right.
And as far as I'm aware, there's not been any allegations of a problem.
I have a copy of this then.
Yeah,
thank you.
Just, they faxed it over.
All right. Okay, so it looks like there's nothing else that this court needs to do, but I guess, Mr. Evans, if you want to have visitation or custody rights affirmed with this child, then you need to take some action.
Do you know how I could do that, Your Honor?
Mr. Steyer can.
We're going to retain an attorney and filing.
Okay, so I have to get an attorney then?
Yeah. Well, you don't have to, but you'd be well advised to get an attorney.
Okay.
And I don't know if they would appoint a lawyer on this kind of issue.
I don't believe they appoint attorneys on this.
I think so.
All right. I'll set your next hearing for February the 12th at 9 a.m.
Your Honor?
Yes.
I live in Indiana. Is there any way we could?
You can appear by teleconference.
Can we do that?
Zoom.
Zoom?
Yeah.
How do I set that up?
You can get the information.
Probation officer who's right outside in the lobby, he'll give you a link.
And that's returning to the review docket. I assume that my reappointment is concluded.
Correct.
Thank you.
Okay, and then what time did you say, Your Honor?
9
o'clock.
Okay. Eastern time. I don't know if
Yeah, make sure you note that if you're in a different time zone.
Yeah, we are.
All right, thank you.
Thank you.
you are.
State of Ohio versus Brooklyn Whittington on a recall, case number CRB 2422.
Mr. Scott's case was just appointed to this morning. We hadn't set the terms of bond yet, so I was letting the prosecutor try to get a hold of the complaining party, and Mr. Scott talked to Ms. Whittington. So now let's decide the bond issues.
Well, Your Honor, and we have had an opportunity to speak with Mr. Scott, and it's reported to me that he's heartbroken that this has even happened, and he does not want a protection order. He wants her to come home. He also says that he said some things to Ms. Whittington that maybe rightfully caused her to get upset. That doesn't mean she should have hit him, but, so what we are willing to do at this time is to, if they'll agree to a time waiver, we just put it on a 90-day continuance, make sure there are no further problems, and then we would dismiss the case with the payment of court costs if there are no further problems.
We're fine with that.
Mr. Scott, you agree?
Yes, Your Honor.
All right, so that would be April 12th.
I will be with the Bar Association on that day, Judge. I can do
15th?
15th, tax day.
April 15 will be the next hearing, and since there's no protection order requested, I won't require her to appear at that hearing if there are, on these conditions, one, no further problems reported, and two, she's paid the court costs. They will be dismissed without her appearance.
Very well.
April 15th is the next scheduled hearing.
Thank you, Judge.
You're welcome.
State of Ohio versus James C. Lemons, case number CR 23701.
Sir, you're James Lemons?
Yes, Honor.
Mr. Lemons, it's alleged that at Union Township on October 23rd of 2023, you purposely deprived Sharon Scarberry of property, that property being a 2004 Nissan pickup truck, and that you did so without her consent and that she was the owner. That is a felony of the 4th degree. The maximum penalty for that is 18 months in jail and a $5,000 fine. Do you understand the charge?
Yes, sir. I plead not guilty to it also.
Do you wish to be considered for a court-appointed lawyer?
Yes, sir.
Do you have a job?
Yes, sir. I go SSI. I got witnesses that she gave me the title. She gave it to my wife at her work and everything. So.
Okay, we should discuss that with the lawyer. I'm going to appoint Mr. Smith as well. We'll get Mr. Smith in the courtroom.
Roger or Tyler?
Well, I meant Roger, but I didn't know Tyler.
Roger.
Okay, sure.
Tyler's here.
He's here now, yes, Judge.
I'll add him to the list. All right, this is James Lemons. It's a felony 4 concerning an automobile or pickup truck allegedly taken without consent. He has appeared on his own without a bond, so I'll give him a no-art bond. Do you have a preference as to a hearing date?
Judge, I'm here the 19th, 22nd, 26th of this month, or the first week of February. The 12th. Yes. That's for your signature bond.
Let's make it the 19th. January 19th will be the preliminary hearing. 10 o'clock. He can sign a $2,500 signature bond.
What you just signed.
State of Ohio recalls Sarah A. Woods, case number CRV 22326, CRV 21686. She's on Zoom.
All right, this is Sarah Woods on a review hearing, 22-326. And 21,686. Okay, and you're the ones that amended reads, right? You must be muted on your end. Your audio is not coming through. All right, Ms. Woods, can you hear me? Okay, your audio is still, there's some problem with it. I see, let me try again, speak again, please. Ms. Woods, can you say something, please? Okay, now I hear a microphone coming online.
Okay.
Now,
Hello?
there we go. All right.
Okay, sorry about that.
Are you still at amended reads?
Yes, sir.
Okay.
I graduated the end of last month, and I'm doing, I'm going to do transitional here.
Okay. So are you in like a sober living facility now, or where are you living?
Well, I'm still at amended reads. I'm just out at one of their transitional houses.
Are you working?
I start either this coming week or the week after with the Recovery to Works program.
Okay, very good. All right, well, we'll keep monitoring you. You have community service to do 5 days, and well, actually 10 days. You got 2 different cases, both have 5 days of community service on them, and you got some fines and costs, and I think there's some restitution in here too.
Yes.
So that needs to be worked on, but first priority was your sobriety, and it looks like you're doing well on that. So I'll give you some more time to try to get this resolved. I'll set your next hearing February the 16th.
Okay.
February 16th at 9 a.m.
Okay. Thank you so much.
You're welcome.
State of Ohio recalls Johnny L. Maynard at the Lawrence County Jail, case number TRC 13976, A, B, and C.
Okay, now we're ready for Mr. Maynard. He's appearing by teleconference. I appointed Mr. Morford to represent him on a failure to appear issue and set, as of now, a pretrial in this case for January the 19th. Mr. Morford, how do you want to proceed?
Judge, I've spoken with him. I've tried to get a hold of Gary Sowers to see if he would take payment for a bond by a debit card. I have not been able to reach him. My client says that he can have all the monies owed paid off by Monday. The problem is exacerbated by Mom not having a car, so she can't go get his money or anything. Do you have a way to get around if you were out, Mr. Maynard, other than your mother?
Yes. Yes, I can get around. I got to call my brother or something.
Okay, you realize that it's been 10 years since you were here.
If I would have known that it wasn't paid or anything, I would have done paid it off a long time ago. I had no clue.
But did somebody tell you they paid it for you, or what?
Well, no, I couldn't get my license back until everything was paid off. And then when I took the test, I just assumed everything was already paid off.
From what I see in the record, nothing was ever paid.
I think you got a little bit of credit, Judge, from community service
I'm not
early
sure
on.
anything. He did community service, but he was ordered to do community service. He did what he was ordered to do, it looks like. All right, so does he want to continue with his not guilty plea? Or?
Yes, Your Honor.
All right, I'll keep it. He's got a $3,000 cash assurity bond. His next hearing is January the 19th, 10 o'clock.
Thank you, Your Honor.
You're welcome. We'll let Mr. Sowers know you want to postpone.
State of Ohio versus Brandon McClaskey on a recall from Lawrence County Jail, case number CRB 2010-565.
Your Honor, Mr. McClaskey, not going to be able to make that bond amount. There's a circumstance as to why he's in jail and what happened to him yesterday. He understands that he needs treatment, and he's willing to go to inpatient treatment, maybe even put an ankle monitor on him if you would like, but he's amenable to that.
Okay. Does he have, what's his pay source, Medicaid?
I should have asked that, I did not.
Are you Ohio Medicaid, Mr. McClaskey?
I got Molina.
Okay. And you're, but that's Ohio, right? You had an Ohio address.
Yes.
Have you been to treatment before, Mr. McClaskey?
It's been a while.
Where?
March area.
Couldn't have been that long.
2021.
Well, yeah, that's not very long.
Your Honor.
Yeah, he's got a date of birth of 2000.
So that's long for him.
Yeah, I guess it's all relative, isn't it?
Yeah.
I've got genes older than that.
So do I. So would that be okay with the court that he, instead of having a cash surety bond, go to inpatient treatment?
Well, let's find him a place to go.
We don't have any beds at OUP, so they're probably taken.
Who's got mail beds?
We have a bed available.
Okay, I'll let you all work it out. Talk with Mr. McClaskey. He needs to be, now one thing you need to understand, and I'm probably going to order a ankle monitor on him because this is not the first time he's missed. He's missed before.
John, he has holders of Iron Municipal.
Oh,
He has
okay.
felony drug and weapon charges.
Okay, well, he's not going to be going today anyway. Those are new charges?
Yes, Your Honor.
He's got new charges about Iron Municipal, so they
Well-
have to get on board too.
Yeah, so I guess we'll just keep it the 19th and see
Let's
what
keep it the 19th and see where we go from there. And if he gets, well, if Iron Municipal wants him to go and agrees, I would agree, but I think he needs an ankle monitor, especially under the circumstances, so.
Okay, all right.
All right, otherwise we'll see you on the 19th.
All right, thank you, Your Honor.
He won't appear in Iron Municipal until Tuesday, right?
Yes, that's right.
Okay.
So, yeah.
State of Ohio versus Daniel L. Cox, case number TRC 231103, CRA 23495. This is an arraignment.
Okay, that finishes up at the jail, thank you. This is Mr. Smith's case.
It is, Judge. He was stranded, I guess, in Lexington, Kentucky. He finally got his car repaired. He came back. I told him, was that?
The car is not repaired.
Oh, it's not repaired. He got back somehow. I told him to come back the first Monday or Friday he was available. When did you get back in town?
I got back Sunday, but my wife was put in the hospital immediately, and she's still there.
Okay. I'd like to get it back on the pretrial, almost on sentencing docket. I believe it might have been on the sentencing docket.
Well,
You're
I'd
going to
like
PRO
for him-
Act,
I'd
correct?
like for him to do a urine.
Sure. Because he was
See
going
where that
to
is.
PRO Act, yeah.
Yeah.
We'll call you back.
He has been in Pro Act. I wanna-
Yes.
Since he missed, I want to see a urine screen first.
Okay, we'll call you back up.
Yes, we're ready to start the pre-trials.
State of Ohio versus Stephen T. Wells, case number TRD 231486, A and B.
All right, Mr. Wells, Mr. Lauder says you have not retained him to represent him. Are you going to retain a lawyer?
No, sir.
Okay. How do you wish to proceed?
I actually wanted to ask, I got it somewhere. I wasn't really sure I know what I was in here for. I wasn't sure what
You're charged with failing to maintain a sure clear distance ahead and driving under a suspended license.
Okay, when I talked to Chris, I think we were off on the wrong page a little bit on it. So he said something to do with insurance or something. That's what I was starting me off. That's what I brought this for.
No, it says that you have insurance.
Okay.
But it says on the ticket, Your Honor, that the suspension is driving under financial responsibility. So
At the time this accident happened, the officer checked that he had.
Yeah, it was in a company vehicle.
But I don't know what the suspension may have been for in the past, driving with some sort of license or insurance issue. It looks like there's two on here. One is from Chesapeake Mayor's Court. And that was released. That was October 2nd, 2021. And then there was one from this court. And this was during that time frame. It was on case number. I don't see a case number added. See a B&B case number. Can you check his name? See it should have been. It would have been a 2022 case. Wells. Stephen T. Wells.
That will go on.
See that one? This went on November of 2022, whatever the suspension was from.
That is the.
Was it not paid or?
Doesn't show that anything's due.
Okay. Was there other cases in 22? It would have been a 22 case.
No, that's the only one. You can check the B and the C case too. No, there's nothing more. On the 22 to 26 15 case A, the insurance is not marked.
Okay, let's pull that file. Sir, if you'll have a seat, we'll pull your old case and take a look at it further.
All right, thank you.
Do you have what's the case number? Give it to Josh.
State of Ohio versus Ryan T. Evans, case number CRB 23723 and TRC 231777, A and B.
This is Mr. McCown's case set for a pretrial.
Your Honor, it's my understanding, and we will slot this as a continuance to the defense, but the state's looking for a witness in this. This is one where allegedly there was a report of improper driving that led to the stop. So the video would indicate that there was none prior to the stop. So I think they're going to try to locate a witness on that. We would ask that it be set for February 2nd, if that's okay. I think I've got several other cases.
Should be. Let me pull it up, check. Yep. Pretrial, February 2nd. That'll be the next hearing, February 2nd. For a pretrial, 10 o'clock.
Thank you, Your Honor.
You're welcome.
And Your Honor, may I approach on the...
Yeah. Is it 15? I think he said for 6 hours. That's the one I was looking at. I asked to look at the file. Yes, they haven't sent it. I'm not looking at the file. No. I mean, you don't have to sit around. Yeah.
State of Ohio versus Heather R. Matney, case number CRB 23658. Heather Matney.
Judge, Miss Matney is mine. She had called me about 9 o'clock this morning, says she's having transportation issues. I texted her a couple times in between then and now. She's trying to find a way to get here. I'll be here for a little bit longer.
Okay.
And then if she doesn't show up, we would ask to continue it out.
We'll call it later in the docket.
State of Ohio versus Eric D. McGuire, case number CRB 23541.
Judge, this one is also mine. I believe the state's ready to dismiss on this one. This is a 90-day continuance for a menacing charge. There's been no further issues. Client has completed required classes. He has paid costs.
And there have been no further issues, Your Honor.
Do you agree with the dismissal?
Yes, Your Honor.
Case will be dismissed.
Yep. Thank you, buddy. Good luck, man.
State of Ohio recalls Stephen T. Wells, case number TRC 222615 AB.
Okay. Well, it looks like it may be a mistake from the DMV. I mean, we're not showing any basis for suspension here on this. And this is the old case, right? Yeah, the 2615. Well, there is, on this case, there is an assured clear distance ahead, but it looks like you struck another vehicle. So what I'd be willing to do, if the state's agreeable to it, if he wants to plead to that charge, we can dismiss the driving under suspension, but you're going to have to get it straightened out with the DMV.
I'm in the process of doing that right now.
Okay.
We're not
State
opposed.
agreeable with that?
We are, Your Honor.
And you had insurance on this, and I assume you've turned this into your insurance company on this accident?
Yeah, it was in a company vehicle.
Okay.
Brakes went out.
All right, I'll impose a $20 fine on court costs. I'll dismiss, that's the A or B case? Probably the B case, isn't it?
The US is the A case.
Okay. The A case, which is the driving under suspension, I'm going to dismiss based upon us looking at the history here. They say it was suspended from a case out of this court. I don't see any reason why when I say they, I mean the BMV.
Right.
Should have suspended you. I don't see a reason for that, but that doesn't cure your problem. You're going to have to get, they could have just made a mistake, read something wrong or whatever. But it's up to you to go back to the BMV and get that straightened out.
Yes.
So, I mean, if they can call us and get information, but we didn't suspend you, I didn't suspend you out of that old case, so.
Okay.
Any questions, sir?
That was what I was getting at with the daughter last time. I was like, I'm lost here.
Yeah.
So I appreciate it.
Well, I understand. When you have human beings, you can have mistakes, and it looks like you may be,
It happens.
unfortunately, the victim of a mistake that caused
It
your
happens.
license to get suspended. So, good luck to you and try to get it straightened out. And you should be able to go to the local BMV office and kind of walk them through that and say, can you help me get this resolved? They're supposed to do that now.
Okay, thank you.
Good luck with that.
So what do I need, do I need to go pay something?
You'll have a $20 fine court cost here, pay that, and you'll be finished with this last case.
I'll go pay it right now.
Okay.
All right, thank you, Your Honor.
You're welcome.
State of Ohio versus Caden K. Fields, case number CRB 23685.
Your Honor,
This is set for pre-trial.
we've spoken with the alleged victim here, and he agrees with our assessment of the facts that this would be appropriate for a 90-day continuance with no further problems. And if that happens, then we would be agreeable to a dismissal upon the payment of court costs.
No objection, Judge.
Okay, that's going to make it April the 12th. 90 days with costs, and since then there's no protection order requested here, right?
That's correct, Your Honor.
So I'll allow him to pay that and not appear on that date, as long as there's no further problems. He can just pay the cost and not show up. If he hasn't paid the cost, or if there's other problems, then he has to show up. If he doesn't, he gets a warrant then.
Would that be $135, the cost, the 110 plus the 25? Okay.
Your Honor, I had it down as there was a TDO.
Okay, let me look and see.
Well, let me look too.
There is a protection order, so do you have any information on that? So,
Well, the victim,
was that addressed with your conversation? The only difference would be if there's a protection order, then I'm going to require him to appear on the April 12th date.
well, we just request that it be withdrawn at this point.
Okay. So he will have to appear, but it'll still be dismissed then if there's no problems and the costs are paid. He does have to appear.
Thank you, Judge.
State of Ohio recalls Daniel L. Cox, case numbers TRC 231103, CRA 23495.
Okay, good screen. Good job. All right, so let's get him reinstated. I do not have a report from PROAC. I've had reports in the past that he was there, and I know they're hard to get reports out of. So let's try to get a report, and I'll put it about a month out. Are you available on the 12th, Mr.
Let's see, I'm available the 9th, February 9th.
February 9th? Okay,
Yes.
February 9th will be the next hearing.
February 9th. 2-9 at 10 o'clock. Get there, we'll see. Thank you. Sure.
Hey, Roger.
State of Ohio versus Shelby Rodriguez, case number CRB 23396, CRC 23816, A, B, and C. Shelby Rodriguez.
This was originally set for a bench trial at noon today. He did not show up at the last hearing. We converted it to a pretrial to allow me to try to find him. His address apparently is no longer valid. His phone, the voicemail box isn't set up. I can't leave messages. I don't know what else to do at this point. I've tried.
All right, I'll issue a warrant in 7 days if he hasn't appeared in that time frame.
Thank you, Judge.
You're welcome.
State of Ohio versus George Wilson, case number CRB 23762.
This is Mr. Smith's case, except for pre-trial. George Wilson.
Judge, this is a case that I discussed with Mr. Heald. The parties are living separate and apart. They will unfortunately not be able to live together any longer. There's been some arrangements made for both of them due to their age and some other issues. Mr. Heald suggested we continue it out, and if I can provide the court and Mr. Heald with confirmation where he's going to be staying, then I'm hopeful at some point we can dismiss the case, but we would ask for a continuance.
What kind of time frame do you think is appropriate, Mr. Smith?
Can I inquire, Judge?
Well, right now he's at his brother's, and then until he gets his, in the assisted living, he's staying at his brother's.
Okay, but
Well,
Tuesday.
you all are going to leave them apart though, right?
Yeah, they're not.
Yeah, they're not here together. They're not.
And I think maybe this is a situation where maybe we don't need to track it any further. We have responsible family members who are going to make sure that they're separate.
Yes.
Yeah, they can't be together.
So we're okay with going ahead and not dismissing it.
Dismissed it out. Thank you, Judge.
Without comment.
Yeah.
All right, it's going to be nollied, which that's a fancy Latin way of saying it's dismissed with the right to refile if there's additional problems in the future, but as of now, it'll be dismissed.
Thank you, Judge. Appreciate it.
Good luck.
Good luck, George.
Thank you.
You're welcome.
Good luck, sir. Thank you. All right, you're welcome. Good luck to you.
Let's bust out of here.
State of Ohio versus Casey J. Jackson, case number CRB 22510, CRB 22165, A and B, CRB 222595, A, B, and C.
Tyler Smith is the attorney for Mr. Jackson.
Where are you? Where are you going? Yeah, I'm still. RS.
Yes. Yeah, that's a really good report, Mr. Jackson. Congratulations on that. And it seems like, to me, you made a turn from where you were before. So I appreciate that, and I hope you can continue down that road. So, I know for a long time it seemed like you were kind of resistant to making a change, and now it seems like the light switch came on and you're on board with it. Is that a fair summary?
Yes.
Okay. How does the state want to proceed?
We don't have an opposition to continuing to allow Mr. Jackson to complete whatever obligations he has with the counseling agency. I hope that he keeps coming back with good reports each time.
Yeah, he's currently, Your Honor, one of the cases was not a complete jury, it's still in the case, and I believe it's still pending in front of
Judge Finley.
Is it Judge Finley?
Yes.
Okay. I believe Mr. Morford actually represents in that case now, so I assume that they're monitoring as well.
Okay.
They are.
So I'd be willing to even go 3 months out under those circumstances. He's got a really good report. He's got no court monitoring him.
That's fine.
Agreeable with that. And this looks like one of the, I think the 22-510 could probably be dismissed maybe at some point if he continues on the path he's on, so it won't go on his record. Okay, so let's come back in March. Let's make it March the 11th.
Yes, Your Honor, that's good.
All right, March the 11th.
Thank you, Your Honor.
You are.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Allison Snyder, case numbers PRC 23-1100 A, B, and C, and CRB 23759.
Your Honor, the pending domestic violence charge is set for trial today, but we were going to move to nolly that charge. We're not able to go forward with the trial today because of needing to get our witnesses and evidence better prepared. So we're going to go ahead and nolly that.
That's the CRB case number?
Yes.
Okay.
And then we also have the OVI pending, which is set for pre-trial today.
Your Honor, we're still discussing the OVI, still trying to come up with a solution on that. If we can ask for one more pretrial on the OVI.
You have a preference for a date, and now the 19th is pretty filled up, so I'm kind of like to go past that.
The week of the 22nd is bad, Your Honor. 29th, maybe?
It's already pretty busy, so how about going into February?
Okay.
There ain't time issues?
There's no time issues, Your Honor. We waive time.
The 2nd is okay. The 5th is pretty full. 2nd, 9th, 12th, any of those days.
2nd would be fine, Your Honor.
Okay, February 2nd on TRC 23. TRC 23 is 1100? Yes, 1100.
Okay.
February 2nd for pre-trial. And 23759 is nollie.
All right, thank you, Your Honor.
You're welcome.
Good.
State of Ohio versus Mary E. Bailey, case number CRB 23711. Mary Bailey.
Mr. Stratton's case, pre-trial.
May we approach, Your Honor?
Yes.
Mary, what kind of dog is it?
He's a part, he only weighs like 15 pounds.
What is it?
He's a part poodle and shih tzu.
Part poodle and shih tzu. She said part poodle and part shih tzu. She's on notice now. Excuse me. Well, I was thinking about that. She's. So, they want you to put it into the animals running for Okay. They want you to plead to the charge, and it'll just be suspended time and just a year probation. What do you think of that? Well, I mean, I don't know. I mean, it's up to you. I mean, the dog bit somebody, so, and that's a problem. We just gotta make sure that.
I'll be on probation.
Yeah, but it'll be non-reporting probation. You won't be reporting. Is that correct, Your Honor?
Yes.
Okay.
Okay.
Okay. Your Honor, we'll plead guilty to the charge. Understand that we'll keep the dog under a tight leash. And just ask for suspended time. And she has a problem getting down here, so we'll just ask non-reporting probation.
All right, Ms. Bailey, do you agree with what your lawyer has said to the court?
Do you agree to you agree to that?
Yes, sir.
Okay, here's the thing, you just have to be careful because now we know your dog will bite, and I understand that the allegation here is that another person, and I don't know if the other is true, but I've been told there was another person that was bitten by your dog. So you have to keep your dogs up. I mean, that's the law in this state anyway. You're not allowed to let your dog run loose, and you have this extra special duty to make sure that doesn't happen when you're on notice that your dog might bite somebody.
Right.
So, to me, you've got two choices. One, you could just get rid of the dog because it bites people. I wouldn't have a dog that bites somebody. Or, if you're going to keep the dog, you got to take extra precautions not to let it get out where it might bite somebody. Because you're on notice now that that can happen.
She will take extra care, Your Honor.
All right.
Okay.
Okay, so anything you want to tell me before I sentence you?
His head came out the collar, and well, first of all, we've been there for 3 years, and we see him all the time. They're like 2 doors down from us, and Casey's never bit her. But Casey was trying to, I told her to pick the dog up when Casey was running over to her, and when she picked the dog up, Casey was jumping up after the dog and accidentally bit her arm.
Okay. Well, then you're telling me that it shouldn't happen again, right?
Right.
This should not happen again.
Right.
Okay.
It won't happen again.
All right, I'll impose a $35 fine, order you to pay the court costs. I'm gonna make it 5 days in jail, suspended. I'll suspend any jail time on the condition that it doesn't happen anymore.
Okay.
No more running loose or biting people.
Okay.
And non-reporting probation, so it'll be level 5 probation with a review hearing July sometime. When's you gonna give me a date?
The 12th.
Okay, July 12th.
And my dog, he'll be 21 on Easter, so he probably won't live that much longer. But he acts like he's 2, so.
So
that's your review date.
Yeah.
Okay.
So once you get done here, you go over to probation. Okay?
One year of non-reporting level 5 probation. Yeah, so he's like 147.
Mary?
Your dog's 147 years old in dog years. It's 7 years for every year.
What do you say?
I know. Your dog's 147 years.
I know.
Yeah.
I've had him ever since he was 3 months old.
Okay, she'll need to check in with Mr. Major.
All right. Thank you.
Her review slide 12.
So go
Yeah,
over there
July 12.
once you leave. Okay?
Okay, so I come back here?
Yes, here on
Just
that.
pay it off and you don't have to worry about it. You don't even have to come back. Pay off your fine court costs.
Pay the fine and court costs, you won't even have to come back.
Okay. Thank you.
You're all right.
Thank you, Your Honor.
Thank you.
State of Ohio versus Casey Bartram, case number CRB 23-513, CRB 23-520. Casey Bartram.
And this is Mr. Stratton's case.
Your Honor.
These are both 90-day cases with court costs.
They are.
It's unpaid.
And it's not paid. Casey Bartram coming into court. He's been called for, has not appeared. So he's got 7 days before warrant issues.
Yes, Your Honor.
State of Ohio versus Cindy K. Van Bibber, case number CRB 23-520. Your Honor, this is set for sentencing, but Mr. Smith says we have some other court
Okay,
obligation.
all right, this is Mr. Tyler Smith's case set for sentencing hearing.
All right. Your Honor, I do have looks like a report dated from last week with drug screen.
She's then going to ARC as outpatient.
That's correct, Your Honor, it's from work. Yeah.
Yes. Okay, your screen is appropriate. The report's kind of negligible as far as the information, evidence. I guess she's been there. Looks like she's compliant from what I can see, and her screens are good. So,
Yes, sir.
how do you want to proceed on this? This has been at this since the fall. Looks like maybe even August.
But yes, Your Honor, she pled back in August of
All right, it's a
M4.
yeah. Maybe we could go ahead and conclude it then.
We don't object to that, Your Honor.
All right. She's already entered a guilty plea. She's been going to treatment at ARC for a while. And looks like it's on the right track. Is there anything you want to tell me, Ms. Van Bibber, before I finalize your sentencing?
I'm actually glad that you sent me there, so I'm clean now.
Good. So you like ARC? You think they were doing a good job for you?
Yes, they are.
Okay, very good. Okay, I'll impose a $25 fine.
Okay.
Order you to pay the court costs. I'll impose a 15-day jail sentence, which I'll suspend on the condition that you complete treatment at ARC. So order you to complete treatment. I'll set a review hearing for her July 12th at 9 a.m. See probation officer to the left as you go out into the lobby.
Okay.
Get your paperwork, and after that, you can do that.
Thank you.
State of Ohio versus Glenn Gibson Jr., case number CRB 10-1078 A and B, CRC 10-2432 A, B, and C. Steyer's case.
Your Honor, my name appears on the docket. I think this may be a pre-trial interview. I don't know if I've been reappointed. It's a 2010 case.
I'm sorry, did you repeat that?
I'm sorry, this is, my name appeared on the docket. It's a 2010 case though, so I'm assuming this is like a pre-trial interview. I don't believe I've been reappointed.
I think that's correct.
All right, thank you.
Okay, and there is a bond up now. So this actually should probably be set as a sentencing hearing, since there's a bond posted December the 18th. He did plead not guilty to failure to appear, and I found he was not eligible for court-appointed attorney. So, have you hired an attorney?
I have spoken to one, Your Honor.
How do you plan to proceed on this?
I plan to, I thought that this was paid a long time ago, and I thought all the paperwork got mailed in on the community service. And at this time, I do have half of the fine with me. And I would plead with the court that they would change the community service to a fine, because I have no way of getting over here to do the community service. And I work 7 days a week and anywhere from 12 to 16 hours a day.
Where do you live?
I live in Barbersville, West Virginia. I have no transportation.
Who do you work for?
I work for A1 Towing.
Well, is there a reason, what would be the reason that I should go back and modify a sentence that was issued in 2010 and it doesn't look like you complied with?
Because, like I said, Your Honor, I was under the impression that who I went through to do the community service was mailing in the paperwork, which is no longer there. So I cannot go back and get him to come in here and say that I did the community service.
Where was that?
It was over at the Owner Fire Department, and he is presently has passed away, to my knowledge, as far as I can tell. And on the Chase Bank, that was, I would have wrote the check to pay here for, I am no longer with Chase Bank, and I cannot find a record of that check. But I am here today to present half of that fine, and I was pleading with the court that you could convert the community service over to a fine so I could get this all straightened around.
Okay, well, I'll have to go back. I mean, that is a very high amount of community service, and I don't obviously remember all the circumstances of what your sentence was at this point, so I'm going to deny that at this point. I may look at the file, but I would strongly urge you to get counsel. See what you've got here.
I can talk to him again today.
From what I'm seeing, yeah, you had an assault charge conviction with a 90-day jail sentence suspended. There was a leaving the scene conviction with a 15-day jail sentence suspended. There was an OVI with a 20-day jail sentence, 17 suspended, so apparently there was 3 days served. That looks like so those are pretty serious charges. I will review the file, but on the face of it, I'm not going to change the judgment entry at this point. So I'm going to keep your bond in effect. I'll set another pretrial. What's your work schedule? You say you're working 7 days a week?
Yes, sir. I was supposed to be at work at 8 this morning.
So which is a better day, Mondays or Fridays, for you to come to court?
Fridays.
February 2nd is going to be your next hearing. And this is a very serious case, so I would urge you to get counsel. Next hearing is February 2nd. If it's not resolved then, I'll probably set it for a trial. Any questions, sir?
No, Your Honor. Do I go ahead and make the payment that I have now with me?
You can make payments, yes. I mean,
I have it with me right now.
You were ordered to make payment or to pay a certain amount of fine, so anything that you pay goes toward that.
So who do I go see today to make that payment?
The clerk. To
Over
the
here.
right as you go out of the courtroom.
All right, thank you, Your Honor.
You're welcome.
State of Ohio versus Randy Thompson, case number PRC 23-1301, A and B. Mr. Morton. Randy Thompson.
All right, this is Mr. Morford's case set for pretrial.
Judge, that was perfect timing. I just got a fax from my office which you've got a copy of. Apparently, he's been admitted
Something
to.
from St. Mary's Medical Center saying he's inpatient at their facility.
Yes, Your Honor, I'm not sure how long he'll be hospitalized. He has non-alcohol related cirrhosis of the liver, I believe, is the diagnosis.
Well, what are you requesting? Are you requesting a particular?
I'd like to, at least a week, Your Honor.
Well, let's go longer than that.
Okay.
How about the 22nd?
I'm here, that's good.
All right, January 22nd will be the next hearing at defendant's request, 10 o'clock.
We waive time too, Judge. Thank you.
You're welcome.
State of Ohio versus Travis Black, case number CRB 23743.
Mr. Morford's case set for pretrial. Travis Black.
We just got another one. May we approach, Your Honor?
Yes.
Hey, so Larry Taylor resigned to contract spike, so that's not. Do you remember the flash officer did just had audio? This one has a video. Some of the things other times are talking not to do that.
Sorry. No, sir. I don't have any problem. I've actually been doing DoorDash. I've been working doing DoorDash.
Do you have anybody here with you from the Blackford family?
No, none of my family, no.
Yeah, with you.
Please talk to him.
Yeah, we get an assessment.
Well, there's only right here for Pat. But once you talk to him further, we'll recall.
Okay.
All right, we'll recall this after Mr. Morford and Mr. Black have had a chance to talk a little further.
State of Ohio recalls Heather R. Matney, case number CRB 23658. Heather Matney.
Judge, I have been in contact with Ms. Matney since we called her the first time. She is unable to get transportation here. She's maintained excellent contact with me. She has appeared here prior, so I don't think it's an issue of dodging the court. The state and I have this worked out. It's just a matter of getting her here to proceed on that.
Okay, you want a continuance then till when?
Which I am looking at the 29th. It's a Monday, so approximately 2 weeks.
Any objection from the state?
Well, we would want it known that we don't want to go beyond this next time because she's already not been here one time.
Sure.
All right, January 29th at defendant's request for a pretrial, 10 o'clock.
Do you want the time waiver field or?
Yeah, if you don't mind to fill it out for me.
State of Ohio versus Christopher R. Hale, case number CRA 23424, CRB 2487, CRB 1964.
This is Mr. Steyer's case set for preliminary hearing.
Here it is.
And there's some older cases also that are on the docket.
Now, pressure.
Yes. Good.
Thank you. Yeah, but Jesse is.
I work now, so I can make payments. Okay, cool. I work every day to start doing all this. Yeah. You don't have to like get all the ones, but just when we come in, if you make a little progress each time, if you do. You mean like the payments? Yeah. I mean, outpatient, small.
Excellent report from Mr. Hale.
Sure. You can get those from. Are there multiple older cases, or is it all one?
2487 was a theft offense with community service and a fine still owed. 1964 was a theft offense with a fine and community service still owed.
Okay, so it's probably. If the fines are, I work at Wendy's now, so if the fines are paid, does the community service still need to be done, or is that?
Yes.
Yeah. Oh, okay, all right.
Both.
Okay. They work Monday through Saturday, except holidays, so.
Okay.
And I don't know if you heard that other guy that came in here, somebody did the work somewhere else and didn't get credit for it. I've never, in 15 years coming to this court, known somebody that came here and did the work not to get credit.
Okay.
I've heard a lot of people come in and say they did it somewhere else and didn't get credit.
I'm off on Wednesdays and Thursdays now, so I can come in on those days and do it.
That'll work. Okay, so we'll go maybe 6 weeks out. End of February.
End of February. I'm available. I'm available the 20th, which is a Tuesday, but I do have court and common pleas that afternoon because we've got a visiting judge on the case.
The 20th or 26th, either one would work.
26th, I'm available.
Okay, we'll make it February 26th, will be his next hearing. Keep up what you're doing.
Yes, sir.
Get in here and get something done on your old cases.
Yes, sir.
That's part of it too, you gotta take care of your past obligations.
Yes, sir.
You can get the exact figure from probation.
Okay.
I don't know if they can do it right now because they're busy.
When are you coming to the office next?
Probably have to leave here.
Okay, if you're sitting there, when I get out of court, I'll just print it off for you.
Okay. All right, thank you, Your Honor.
Thank you, Your Honor.
Thank you.
State of Ohio versus Bobby Johnson, case number CRA 23235. Bobby Johnson.
Mr. Steyer's case, preliminary hearing, Bobby Johnson.
wish his son was here. Situation.
You left out. Let's call back up. Let's call back up. Yeah, she's in through. Yeah. We don't want one, but she's in patient. Tell you her name. She went to treatment. Yeah. Okay, sorry. This is on a cleanup issue, right?
It is, and we don't have, and I apologize for not having an update, but I also believe that Mr. Johnson's no longer living in that residence, if I.
No, I'm still living, it didn't work out.
Well, you are living there?
Yeah.
Oh, okay, I thought it had been.
Has there been any more cleanup done?
The guy that cleaned up, he didn't get it all, and the dumpster and stuff, he just took off and left some
Oh,
stuff.
I recall that from before. They paid somebody to do the cleanup and the person took the money and left.
I was supposed to get in Sherman Towers, but that didn't work out in January. It's coming, but I don't know when.
And I don't know what's gonna happen to the property, or whether it's
It's still up for auction.
still up for auction.
Okay, that's why I didn't think you were there, because it had been.
I think we just need to continue this again, just to track it. I know Mr. Steyer would rather us dismiss it at this point, but I don't think we can.
We're coming back on the 26th already on another case. Can we just set this on that day as well, Your Honor?
Defendant waives time.
Yes, we waive time constraints.
February 26th for another preliminary hearing.
State of Ohio recalls Kirsten Shipman, case number CRB 23698.
Okay, Ms. Shipman is Mr. Thompson's client. She had been ordered to go to inpatient treatment with Bethesda and to report on Tuesday the 9th, which she failed to do. She has a bond up with Mr. Sauer, so a warrant was issued, and then when he started rattling the cages to try to find her, she reported to Hometown Recovery. And then they sent her on to Foundation for detox.
She's in detox.
She's still there?
Yes, she was actually supposed, I guess somebody dropped her off at the office that day. We had no idea, and she wanted to go to detox. She was supposed to come here Friday, so we had no idea she was coming.
Okay, I understand she did this on her own.
Yeah.
But at least she's in treatment now. She's, as far as you know, still on Foundation.
She is in Foundations. She did sign a release, and as soon as she gets out of there, we will bring her straight back here on the next date.
Okay. I'm wondering, inpatient, when she is released from Foundation, she had a terrible screen
Yes.
on January the 8th for amphetamine, benzodiazepine, fentanyl, ecstasy, methamphetamine, for all the things she tested positive for. Young person.
Very young. We've had her in treatment in the past.
Okay.
A couple years ago, and I don't know if that's why she came to us or not. But we also had, I believe, another relative that dropped her off.
Well, I'll be okay if she's either inpatient at your facility or at Bethesda.
Whatever you want.
I'm going to set her next hearing. Let's see, Mr. Thompson texts me as to when he's available. Let me check. He says he's available for the 19th of June. She should be out of detox by then, shouldn't she?
She should be.
So I'll put her on the docket for 119. He says usually he's not available on Fridays, but he says he is available.
Okay.
So that'll be 119 at 10 o'clock for pre-trial.
Okay, thank you, Your Honor.
You're welcome.
That's what I thought. He's agreed with these. Okay.
No, I'll withdraw more till the 19th. But I'd like to know if she leaves detox or doesn't stay in treatment, I'll reissue the warrant, and she has a bond up, so Mr. Sowards would go track her down. I think that's why she turned herself in, because he started making phone calls to family members to try to find her.
I think he contacted a family member, and that's the family member that just dropped her off.
Dropped her off.
Yeah.
Okay.
State of Ohio versus Sean A. McComas, case number CRA 24-2.
Do you want to talk to him then?
All right, Mr. McComas, you have an attorney today?
No, I don't.
And I'm assuming this is Jacqueline?
Yeah, it is.
Jason.
Jaslyn?
Jason.
Caldwell.
Yes, sir.
This is a file, is a felony file.
Yes, sir.
This very seriously. We think he needs to do that marriage.
Yes, sir. Maybe she is the situation is we taken proportionally very huge misunderstanding. My father was forced the call live on him a lot, and there's been a lot of issues in the past with him. My father and I no longer on speaking terms. He has told me to kill himself multiple times. So we I've got another picture of everything. This
But you wrote a statement. And you were very detailed about it. I mean, if you're saying this isn't true, then you've committed a crime. Yeah, but what you said. So I'm going to take this very seriously. So, Your Honor, I've been speaking with Ms. Caldwell with respect to the written statement that she made, which is very indicative that, she's saying that there was domestic violence, but is now wanting to say that it's not true and putting everything on her father, forced her to make a statement. We're not buying that necessarily. The reason it's filed as a felony is because Ms. Caldwell is expecting at this time. She wants this thing dismissed immediately, which we're not willing to do. We would be willing, however, if Mr. McComas is willing to be assessed for anger management counseling, we would be agreeable to holding on to the case and seeing whether we need to take it forward as a felony or whether it can be resolved here. We're not making any promises at this point, but it is serious.
All right, Mr. McComas, how do you wish to proceed?
Not guilty. And I agree to do his anger management or anger assessment.
Okay. And I know you're not a lawyer, but in essence, you are representing yourself, but you haven't hired a lawyer at this point. What the prosecutor is saying is, and this is a little bit complicated issue, you're charged with a felony offense. What that means is you have to be indicted before that case can go forward. So a group of your fellow citizens that meet in secret have to listen to the evidence the state says it has and says, there's enough evidence to go forward with this case and we issue an indictment. That's how serious felonies are. You have to be indicted by your fellow citizens before the case can go forward.
Like my peers? Like coworkers?
Your
Okay.
peers.
That's
Well, no, not your coworkers. People chosen by rank.
Oh, okay.
It's a grand jury. It's kind of, you're probably more familiar with the petit jury. That's the trial jury that hears the case in open court and makes a decision whether you're guilty or not. But a felony is so serious that people from the community have to listen to what the state says it has against you and agree you should be charged for it. Because a felony you can go to prison for if you get convicted. Okay, so that's what you're charged with, a felony. Because she's pregnant, that makes it a felony. What the state is, and that's what I'm trying to decode this for you because I know you're not a lawyer. The state is saying, we will not pursue an indictment. We will not take you to the grand jury. We will not take you to the, see, I can't try a felony trial here, only the preliminary hearing. They will not take you to the common pleas court in Ironton on a trial for a felony if you agree to keep the case here and go to counseling and do it in successful counseling and without saying that anything, nothing will happen like is alleged here again.
Yeah.
It's alleged that you were threatening to her, actually physically, shoved her, got in her face, headbutted her. I don't know whether that's true or not, but that's what's alleged.
Yeah.
Okay? So if that did happen, that's totally inappropriate and criminal.
I agree.
So, what they're saying is, what the prosecutor just said is, if you'll go to counseling and that's successful, you complete it, and there's no further incidents, then at some point down the road, I take it they would agree to dismiss it and not take you to the grand jury for an indictment.
Okay.
Is that something you're interested in?
Yes, sir.
Do you want to talk to a lawyer before you make that decision?
No, I don't need to.
Okay, that's your choice. I can't make you hire a lawyer. As I recall, I made a note of this, I questioned you about your financial circumstances, and I didn't think you were qualified for a court-appointed attorney because of your job.
Yeah, but I found out, it was only 16 an hour, with bonuses and everything like that. It's not usually that much, so that's why I didn't think I could.
All right, do you want me to reconsider you for a court-appointed attorney?
Yes, please.
Where do you work?
Barbersville Waffle House.
Okay, and you're paid 16 an hour?
With bonuses, but it's $14.75 an hour.
How many hours a week?
About 36, 38.
How long have you worked there?
About 5-6 months.
Do you have any money saved?
Not much.
How much?
A few hundred, maybe.
All right, I will appoint Mr. Steyer to represent you. So, I think, Mr. Steyer, you were here and heard, hopefully we're paying attention to what.
I did, Your Honor.
You want to talk with him and come back and see how you want to handle the offer is for him to go to counseling, and if it's completed, that the case would never go to the grand jury, stay here.
Yeah, I'd like to speak to him and speak to Mr. Hill briefly and then have the case recalled.
Come forward, take the court's file, let the bailiff know when you're ready to discuss it.
Get one of these papers?
Not yet. I don't know what to talk about. Wait for a second.
State of Ohio versus Taylor Bryan, case number CRB 2112, CRB 2312.
All right, Ms. Bryan, it's alleged that you failed to appear for a review hearing a week ago, January 5th.
Yeah,
You dare deny that?
I did it. I wasn't here. I thought it was on the 4th,
Yeah.
which was a Thursday, and I didn't
Okay,
think
so
that y'all was open.
you're saying you got mixed up on the time.
Yeah,
So you've done, on one case, you've completed your community service, and another one, you still have 22 hours. You've done 8 hours out of 30, and you haven't made a payment for a while. Can you make a payment on your funds?
I don't know when I can do that, but I can work community service this week.
Okay. Like tomorrow?
What is tomorrow?
Saturday?
Yeah, I should be able to.
Okay, Mr. Cooper's got you down for tomorrow. I'll withdraw the warrant, set your next hearing for February 2nd for review at 9 o'clock.
Okay.
Be out here tomorrow, and you'll let me know if you don't show up.
Yeah, I know.
You gotta be here at 7:30.
Okay, thank you.
Set your alarm clock.
I will.
Nobody, I should have said your phone. Nobody has an alarm clock, especially her age.
Clock radios are gone.
It's true.
State of Ohio versus Andrew Carr, case number CRB 24-7.
It's like the older.
Except there's a refund. There is a refund.
Okay, this is set for sentencing. And it looks like he needs to go inpatient like he agreed to.
Yes, Your Honor, we have a bed, so they will be picking him up once we're finished.
Okay. All right, well, I'm gonna, so that I can keep you on the hook with your bond, I'm just gonna delay sentencing again. You're gonna go to treatment, and if you run, then I'll sick Mr. Sowards after you to go fetch you wherever you go to. And he just went, was it Gulf Shores?
Yes.
Florida? Is that Florida? Alabama, Gulf Shores, Alabama. To get somebody, and they didn't think you would come that far.
Dang.
So, don't run. There's nowhere you can run and hide.
I know it can be done. I've had 16 months clean before. That's why me and my wife moved down here. We went through Lifehouse and graduated it, and then about 3 months ago I fell back into it. So I know once I get the initial hump in, I know I can do it.
Okay, I'm gonna set your next hearing for February 2nd.
Yes, sir.
You should be still at OVP, and they're gonna let me know if you quit or leave the program.
Yes, sir.
All right, thank you, Your Honor.
Next hearing, February 2nd, 10 o'clock.
State of Ohio versus Derek C. Willis, case number TRC 22-160, A, B, C, and D, TRC 14-901, A and B. Derek Willis.
Derek Willis is set for sentencing.
It's a sentencing review.
He has a bond with Sours now. Just have to find it. Okay, let's can't immediately lay hands on the bonds, put it on my desk, and I'll find it after court. There'll be a warrant issued, and I'll notify Mr. Sours that he failed to appear today after I find the bond.
State of Ohio versus Daniel L. Lucas, case number TRC 231414, AB and C.
It's Mr. Smith's case, sentencing. Probably put that one back in, unless it's hours, and I'll be correct. So would this be a second or third?
This is a third. Yeah, I think we're in this. It's kind of ambiguous.
It is a third. The understanding was the state, there was no guarantee, would possibly admit it to a second if he did what he's supposed to do. He spent almost 30 days in jail. How long were you in jail for?
27 days.
27 days, so we're hoping that we can resolve this successfully. I don't know. This report seems good, but it seems like there's some issues, so I don't know if we're at that point yet that we could do the sentencing. I would defer to the state as how they want to proceed at this point.
Well, my feeling is no, but I want to try and talk me out of it.
Well, one thing is he did do several days in jail already, so I don't know exactly how many, but
27.
But the report seems a little ambiguous. On the one hand, the last paragraph talks about his good work ethic. He's working, not received any behavioral interventions, positive attitude, compliant with all the rules and regulations. But the first paragraph talks about the fact that he minimizes the issues. So I don't know how he got to where he is in the program. if that's negative attitudes holding him back. I don't really understand that. Maybe it could be explained to me.
So he's minimalizing alcohol use, and his roommate's abusing alcohol. So he's wanting to go to outpatient, and I'm not comfortable recommending that right now.
I'll stay in the crossroads.
Well, and here's my thing. I mean, he's charged with a third offense, he's pled guilty. Floodgates, keep saying the floodgates. We've opened the floodgates on, and I think there's a legitimate reason. You know, I'd rather see somebody deal with their problems and not come back and have an issue in the future than strictly comply with what the law says I have to do, which is jail time. If it doesn't fix the problem, then we know from people that study this, jail doesn't necessarily fix your substance use problems. But I'm not going to give you the benefit of a reduced jail sentence with a report in the file that says you're not, it's got to be a sterling report before I'm going to say, oh, this third offense, I'm going to treat it as a second offense with something like this. If I go ahead and sentence him as a second offense, he goes out, relapses, has another incident where he kills himself or somebody else, that should be placed on the front page of the Herald-Dispatch and the Iron Tribune.
Probably would be. Judge, he's willing to stay at Crossroads. We talked about this. He's still got more work to do, and does not want at this point to be considered for outpatient. He's willing to stay at Crossroads, do what he's got to do, hopefully get us to the finish line sooner rather than later, but that depends on how he does. So we have no objections if the state doesn't get another date. Hopefully get a report that he's not minimizing his behavior in that next report.
Okay. We need a better report.
Yes, sir.
Okay? If you want to get the best possible outcome, I don't want anything in there that's negative.
Yes, sir.
I want to be convinced that you're never coming back here again. Or that you're ever going to put yourself or other people or me or my kids or my grandkids, we're all out there on the highway. I don't want to be at risk from you causing another problem. You understand that?
Yes, sir.
Convince me. February 26th?
Should be fine, Judge. Fine. Yes, I'm here then anyway, Judge. That's fine.
February 26th will be the next hearing for sentencing.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
I'm going to recall this Derek Willis case, 220160, because I misspoke before. I assumed it was Mr. Sauer's bond. There is a bond up. Mr. Willis failed to appear today, but the bond is through Peach Bonding. So, not Mr. Sauer's. So will you need to notify Mr. Peach that Mr. Willis failed to appear, set a bond forfeiture hearing for February the 9th? Probably should do that by letter. Maybe since we don't deal with him all the time. Certified mail, return receipt. So bond forfeiture hearing and issue a warrant today for Mr. Willis.
State of Ohio versus Austin T. Hawthorne. Case number CRB 2357, CRB 2358, CRB 2843, TRC 191305 A and D, CRB 19393. Austin Hawthorne.
He was doing so good. You had any contact?
I have not, Your Honor.
Nor have I, Judge.
All right. I'll issue a warrant for failure to appear. He was at the counseling center. I don't know if he's still there or not.
I'm not sure, Your Honor. I'd have to make a phone call and see if I can find out. But
Yeah.
I believe he may have left, but I can't confirm that.
Well, he has a felony pending. Do we want to send it to the grand jury, or what do we want her? Well, why don't we put it back on the docket just to make sure, because he had been at the counseling center for quite a while. Rather than issue a warrant today, I'll reschedule it for the 22nd, and we'll look in to see if he's still there. Before issue, but then you can make a decision if you want to take it on to the grand jury or not. Yeah, one of these cases is a felony that's never been resolved.
State of Ohio versus Dylan Hayden, case number CRA 22-473, CRC 22-2096, A and B.
Mr. Morford's case.
He was, he's still, but that,
Yeah, he's still in the inpatient treatment.
He does
very well.
good.
How are you?
I'm good, thank you.
13 days away. Leaving, graduating. Right.
Good deal.
Yeah.
Got yourself.
All right.
Your Honor, he's very close to graduating from inpatient treatment. I believe he has less than 2 weeks.
You understand what?
Well, we've been monitoring this for a long time, and we've been up, down, and around. Mr. Hill, do you have any input on it?
Well, we want to make sure he crosses that finish line and gets graduated.
10 days.
He pled to the OVI a long time ago. It was a first offense. And then we have the felony possession charge pending, and if he crosses the finish line, we'll agree to dismiss that charge.
What's the plan after you finish your treatment?
I'm going back home, and then I probably will be sent to Atlanta for training for Norfolk Southern Railroad.
Oh, okay. So we're looking at you finishing up around...
The 25th is the graduation day.
Okay. When we come back February 2nd, are you available then, Mr. Walker?
I believe so, Judge. Give me 1 second. I'm here then, Judge.
All right, February 2nd, I'll try to wrap this up then.
Sounds good.
See you then.
Thanks, Ron.
Yes, sir.
Thank you, Your Honor.
Thank you, Judge.
State of Ohio recalls Travis Black, case number CRB 23-743. Travis Black.
Here, Butch.
He's here.
Travis Black, come into court.
No answer, Your Honor.
I just saw him. He was in the courtroom.
After I talked to him, he came in here, Judge.
He left my towards the flea market, Your Honor. What's they're telling me outside?
Yeah, he's not out there.
Okay. He has a bond up. Yes. Okay, I'll issue a warrant for his arrest today and notify Mr. Sowards bond.
Thank you, Judge. Are you going to notify Mr. Sheriff, Judge, or would you like me to?
I am.
Okay.
I'm sending him a text now. February 2nd.
That's good, Judge.
The bond forfeiture hearing February 2nd.
Judge, what we discussed at the bench, I think there is a urgent need to have him evaluated.
Okay. Apparently so.
Thank you, Your Honor.
You are.
State of Ohio versus Sean A. McComas on a recall, case number CRA 24-2.
You too, Butch.
Your Honor, I've discussed the matter with Mr. McComas. Okay, I'm sorry, Lever.
Sorry.
That's all right. I've discussed the matter with Mr. McComas. He is willing to undertake an assessment for anger management. Where do you live?
Proctorville.
Do you have a medical card?
Yes.
Okay, so he has a medical card, so we should be able to find somebody that'll take him for anger management. He lives in Proctorville. I don't know what's close to who's close to Proctorville. Okay, so we're gonna get him assessed. He's willing to do that. I've discussed the matter with the state. The state's in agreement that there's no further problems and the anger management is undertaken and completed, that we would do a 90-day continuance, and the state would be, at that point, if everything goes right, and only if everything goes right, would be willing to dismiss for the payment of court costs, which we're agreeable to.
You agree, Mr. Hill?
Yes, Your Honor, and given everything that I've heard from everybody here this morning, I think that's the best route at this point. And I hope that Ms. Caldwell will, she could take part in counseling too. If they're having a child together and they intend to stay together and they're both young, this is an opportunity for them to learn something about maybe grow a little bit as individuals, as a couple, so they don't have these kinds of things that arise and end up in court. So
Agreed.
we're hoping that everybody will take it seriously.
So, Ms. Caldwell, I can't direct you to go to counseling, but I think it's a great idea that you go with him.
I would like that.
Okay, so once you talk to Mr. Gwynn, they have RRS, who he works for, that's here in Chesapeake, so it wouldn't be too far for you to go.
Thank you, sir.
So he'll talk to you before you leave court. I'm saying the next hearing, April 12th, I think they should come back for that.
Let me make certain that I'm available April 12th. I don't think there should, okay, no, actually on the docket already, so that worked out perfectly.
We'd like to come back sooner than that.
You want to come back before that?
Just to
Okay.
make sure that the counseling's been started and
How about February 12th then?
I'm here February 12th. Is Monday or Friday better for you? Does it matter?
Monday.
Monday is better anyway, so that actually,
Okay, that is a Monday. February 12th will be the next hearing, 1 month from today. Talk to Mr. Gwynn before you leave.
there you go. You can shoot me that text later on. Thanks.
State of Ohio versus Gregory Wiley, case number CRA 20-624.
Stire's case, one million.
Oh, thank you.
Your Honor, he is compliant with our program. He is due to, coach,
Yes.
he is due to complete on the 26th of this month. And he's going to follow up with outpatient at OBP in Huntington. He still has his housing voucher, so he just plans to get his own place and continue in outpatient, but he's doing great.
Do you have my card? Let me give you a card.
And when did you say he's gonna graduate?
The 26th is the day he completes.
Okay. Well, I'd like to come back after that at some point just to see that he has transitioned and is doing his outpatient.
Okay.
So sometime in February, I would say 1st of February.
Make sure you can read my handwriting there.
What's your schedule?
Let me get a quick look at my calendar. I think I'm available the 9th or the 2nd.
9th's better.
Okay.
February 9th. So you know, then they'll help you, I assume, set up an outpatient facility in Huntington to follow up with.
Yes, he'll have that before he leaves OVP.
Okay. February 9th will be the next hearing, 10 o'clock.
Thank you, Your Honor.
Thank you, Your Honor. Good work. Thank you, sir. Thank you.
Okay.
State of Ohio versus Mary Cecile Ellen Pater Rubel, case number CRB 23622.
This is Attorney Roger Smith's case, and it's set for a trial today.
It is, Judge.
Is the state ready to proceed?
Yes, Your Honor, we are.
Bennett's ready to proceed?
Yes, Judge.
Is there any request for a separation order, or?
If there's any other, we have our victim here as a witness. That's our only witness.
Judge, we have potential defendant, no other witness.
Oh, yeah, we have an officer too, but he's in there.
Well, there's an officer, I would ask for separation.
Well,
But
which one?
he's probably going to testify first, so it really won't matter. It's kind of a moot point, I guess.
Okay.
Is he going to testify first?
Thanks for making up my mind for me. I didn't know.
Well, I guess that's the way it works, but if you're changing,
Yeah, that's fine.
either way.
I would like to make an opening, just a brief one, just to kind of set the parameters of this. And Your Honor, this is an incident which is alleged to have happened on October the 15th of 2023. And this is a brother and sister, and they live in adjacent properties that used to belong to their parents, and they are residing next door to each other. And the property that our victim, Claude Pater, has has the benefit of an easement that goes across Miss Rubel's property to reach the road. And on this particular day, I believe the evidence is going to be that Mr. Pater was cutting down some trees and whatnot on the right-of-way in order to be able to use the right-of-way. And it upset Ms. Rubel, and she physically assaulted Mr. Pater. And we believe that'll be the evidence. We actually have a statement, written statements from both parties as to what happened. And so that's, we're going to have the officer testify about that, and also Mr. Pater will testify about what happened.
Mr. Smith, do you have any statement?
I do, Judge. There is a right-of-way. This is a situation where it has not been used in excess of at least 20 years, maybe 21, 20, 22, 23 years. My client lives close to the road. That's where the house is, the part of the property that she got. Mr. Pater, I believe, somehow caught wind that she'd spoken with Rick Bentley about how do we close a right-of-way that's not been used over 20 years. He got wind of that and decided he's going to clear cut the right-of-way, knock down these 100-some-foot trees, a 100-year-old pecan tree. She asked him to kindly don't mess up the right-of-way. She called the sheriff. They showed up in the morning. Mr. Pater went away, he came back later that afternoon and decided to finish the job. And the evidence will be that she did not physically assault him, she didn't threaten him, she didn't do anything other than, as he was cutting pecan tree, she did tap him on the shoulder, say, stop, and she got between him and the tree, so he couldn't finish cutting the tree. Until the deputy put her in handcuffs, took her to jail, then he finished chopping the tree down. So I think at the end of the day, there's not going to be proof sufficient that she physically harmed her brother or tried to physically harm her brother.
All right, call your first witness.
We'll call Deputy Orsbon.
Deputy, if you raise your right hand, I'll swear you in. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth to help you God? Step up there to the witness stand and be seated, please.
Sir, state your name and where you are employed.
My name is Deputy Shane Orsbon. I'm employed at the Lawrence County Sheriff's Department.
And you're a deputy with the department?
Yes, sir.
Were you on duty on October the 15th, 2023, and were you dispatched to Proctorville in Rome Township for a domestic violence complaint? Who made the complaint, as far as you know?
When I originally got the call come through as a third party. When I arrived on the scene, there was an accident in front of the house, which was the fire department. The fire department's the one that kind of told me, hey, this is what we seen. We're the ones that called in.
I see. So they were there on a separate thing?
They were there on a separate thing, yes.
To your knowledge, have there been a sheriff dispatched to the same place earlier that day?
I checked to ask if there's been any any incidents or anything before I go, especially if it's a domestic, so I kind of know what to expect. And there was a deputy there for a verbal altercation between the parties earlier that day.
When you arrived there, did you make contact with Claude Pater?
I did.
Do you recall what Mr. Pater told you had transpired?
Mr. Pater explained to me that him and his sister had a verbal altercation. They were arguing over an easement that goes across the front of what used to be his mother's property to his property. He stated that he wanted to clean the easement, get the trees off of it so he can start using that right away, that he was getting ready to put in another trailer and he needed the access to that property for that trailer.
Did he tell you anything about a physical altercation between him and another person?
He did. He said that when he got his chainsaw out and went to onto the easement to cut the trees off of the property, that he once he put his chainsaw into the tree, he felt his sister hitting from behind and shoving, and that's when he shut the chainsaw off and asked her what she was doing and what was going on.
Did you get a written statement from him?
I did, yes.
I've had this marked as State's Exhibit 1. Ask you to identify what that is.
This is going to be the incident form that Claude Pater wrote on the day that I was there and made the arrest.
And he alleged in that he was assaulted physically by Mary Rubin.
Yes.
You have this, right? I'm going to ask that Exhibit 1 be admitted.
Subject cross-examination, Judge.
All right, please, admitted.
Did you talk to Mary Rubin?
I did, yes.
And did she tell you, from her perspective, what happened?
She did. She actually, when she seen me pull in, she actually walked down to my vehicle. She explained that she was married. She inherited the house from her mother. Her and her brother was having a dispute about the easement. She stated that he does in fact have an easement there, but he never uses it. He uses the access on the back side of the property from another street. And she didn't understand why he was cutting the tree. She knew that he didn't. That he knew she did not want him to cut those trees off that property. Once I asked her what happened, what went on, she said that she was very angry. They got into an argument earlier because he threatened he was going to cut the trees off the easement. That's what the officer was there before. After that, once she seen that he was started cutting the tree, she went up to him from behind, shoved him, and was screaming and telling him he wasn't going to cut the trees.
I've had this marked as State's Exhibit 2. Did you take a statement from her?
I did, yes.
I'm going to show you what I've marked as State's Exhibit 2 and ask you if you know what this document is.
This is the incident statement that I took from the day.
And this is the authentic
Yes, sir.
reproduction of that.
Yes.
In this statement, she actually write and admit that she shoved toilet paper.
Yes, she was telling me that she did make contact with him.
I'm going to ask the State's Exhibit 2 to be admitted.
Mr. Smith,
Again, subject to cross-examination, objection, Judge.
be admitted.
Do you recall Ms. Rubel, and do you see her in the courtroom today?
Yes, ma'am, she's sitting with her attorney.
Ask the court to recognize that he's
Yes,
identified
record
her.
show, he identifies each one.
That's all I have this witness, Your Honor.
Mr. Smith,
Thank you, Your Honor. So as I take it, you did not witness my client lay her hands on her brother, Mr. Page, is that correct?
I did not witness her touching him.
Okay. And are you aware that my client is the one who called earlier that day to have the sheriff come out or a deputy come out to the property?
I did learn after that she was the one that called
Okay.
previously to me being there, yes.
Okay. And did a different deputy answer that first call than yourself?
I did not answer the first call.
Okay.
That was another Deputy Easter.
Okay, well, you weren't there, so I'm going to ask you questions about that, but. And in the report you took, you indicated that Mr. Pater said to you he was not interested in pursuing charges if she just stay off the easement, is that correct?
He did state that he didn't want to pursue charges if he was able to take care of the easement and do what he needed to do, and she was no longer going to assault him.
And this was said to you, obviously you were the second time, correct?
This was told to me after I had Mr. Paterman fill out the paper, after they filled out the statement of what happened.
Did you see any physical injuries on Mr. Pater?
There was no physical marks that I can visually see.
And you say my client was upset about cutting down this pecan tree and the other trees on the right of way, correct?
Yes.
Now, the term push, did she physically shove him, or did she get between him and the tree and put her hands up on his chest and say, stop cutting the tree down? Do you know exactly what happened?
The way that it was stated to me from both of the people was that she come behind him and shoved him and got him away from it and got in between the trees, how Mr. Verbal stated it. He stated that she come behind him and was hitting him and he shut the chainsaw off.
Okay.
So they both stated that she physically assaulted him.
Okay. Did what you characterize as physical assault, did it cause any physical injury to Mr. Pater? Did he have to be transported by EMS? Did he complain?
He
of
was not transported by
chest
EMS,
pain?
no.
Okay. You said the second call was from someone with the fire department, the Rome Township Fire
This
Department?
was the Rome Township Fire Department.
Did you take the names of those firefighters?
The one that was there was Mr. Edwards. I did get his name, and I told him that I may need a statement, depending on how it went there. I did not have him fill out a statement because both Mrs. Rule and her brother both stated that she did touch him.
So did you provide that name to the state?
Fire
officials.
I do not think I put him in the report, no.
Did you take any photographs of the incident where this occurred?
I don't believe I did.
Was it closer to the main residence or closer to Mr. Pater's residence?
This was going to be closer to the complex 7 than her residence.
Okay. Have approach with the judge.
Yes.
Photograph and see if that photograph is the truck that you saw when you arrived.
When I arrived, there was no truck there.
Okay. Is that the area where you're referring where the incident took place, close to that house?
This is
Okay.
where you have the tree, the one tree down and the pine tree there.
Okay.
In question.
So it's not alleged that she used any type of weapon on Mr. Pater, is it?
No, she did not have a weapon.
Well, I'm curious, Deputy. Mr. Pater said he did not want to pursue charges, but then charges were pursued.
That's correct.
Did he change his mind? Did you say, I'm going to file them anyway? What happened there?
I did not say I'm going to file them anyway. What was stated was that this was a civil issue between them cutting the trees and so on and so forth, that I could not get involved in the easement, the right of way. I stated this to both parties. He's the one that insisted. When I talk to her, I separate the two of them. So I have her over here and I have him here. When I go to talk to him, she come behind me and she's talking over me to him. So I separate her again. That's when I stuck her in the back of my cruiser and said, hey, I'm going to have you sit here so I can communicate to him.
Fair enough.
When I went back up the second time to communicate to him, he said, I'm going to go ahead and press charges. That's when he decided he wanted to go ahead and press the charges.
So first I told you I don't want to pursue it, then he said I think I will pursue it.
Yes.
I have no further questions, Judge, this witness.
Redirect.
Just one question, Your Honor. I'm looking at your affidavit from this, and it says in the last sentence, the male stated his name was Claude Pater and he was cutting a tree off the right of way when he felt someone pulling on his clothes and started hitting him, screaming. He shut off the chainsaw and asked her what she was doing, that they had talked about clearing the easement earlier when the deputy came, and he did not know why she was hitting him, but if she was not going to stay off his property and out of the easement so he could clear it, then he was filing charges. That's an accurate statement of what happened. In a domestic violence situation, generally you make a report anyway, don't you? I mean, whether somebody
Regardless, there's a report, when there's a domestic violence, regardless, we make a report, yes.
That's all I have, Your Honor.
I cause no recross, Judge. No, sir. Thank you.
You may sit down. Thank you.
Thank you, guys.
Thank you. We'll call Claude Pater. Claude? Yeah, Claude.
Just move that there. Yeah.
Mr. Pater, if you'll raise your right hand, I'll swear you in. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Claude, give a report your full name, please.
Claude Pater.
What's your address?
361 Township Road, 1053, Parkville.
We've had some testimony already that your sister is Mary Rubel, who's the defendant here today. Is that correct?
Married.
Mary Rubel.
I was known as Alan.
But it is this lady it's this lady that's sitting over here, right?
Alan's married now, but it's Alan.
It's Ellen.
Okay, well.
It's a confirmation name, I'm sure.
Okay. But it is this lady over here.
Yes.
And you live in Rome Township in Proctorville, right?
Right.
You live on a piece of property that used to be.
We all live there as a family.
And so it was divided up into 2 parcels.
It's been divided 4 ways. After my mom passed away in 2013, November the 21st. Alan and my brother, John from Texas, they left in the 80s, you know.
Okay, well, I just want to let the court know what we're talking about. Do you recognize this as a map of where you live and where her property? Now look over your shoulder. So yours is the piece of property that's on the left side,
Correct.
and your sister's on the right side,
Right.
right? And then on the lower right-hand side of her property, there's a line there that indicates an easement, right? And that easement serves your property, right? So that you can get to the road from your property, right?
Yes.
Now, on this day,
It's an easement on her property.
Sir,
But my property could go
yeah.
through that because I financed the mobile home and they wouldn't go away. They financed it unless, because I was in the landlord.
And I'm going to ask that this exhibit 3 be.
Okay, any objections?
None, subject to cross-examination, Judge, no objection.
Now, back on October the 15th, 2023, sheriff deputies were called to your place there and where your sister lives 2 different times, right?
Correct.
And the second time, we had Deputy Orsbon just testify about what happened.
Correct.
And I would like for you to tell about what happened the first time and the second time.
Well, the first time, I have a brother who lives in Texas. Haven't seen him probably 3 years, you know. He just pops in 2 or 3 years. They don't come over to my place. I don't know what I did. You know, they pretty well pulled the rug out from under me.
Gee whiz. I'm sorry. All right, what were you doing that day? Were you working on the easement?
I live on mine, yes.
Were you working there on the easement, clearing brush and trees and
I've
stuff
been
off the
doing
easement?
it for the last 3 summers. And Alan's well aware, he pops in. The house has been abandoned for a long time, grass grows and all that, and it is my easement. There is 2 ways I can go out, come in. And I do take a shortcut through her place. It's my easement. There's, years ago, it's my childhood place. I planted some trees, the Christmas trees. Those were grown, and I am going on her property. I got to take them down, and she's well aware of that. Told him I'm cleaning on the fence line. They don't clean or cut no brush. I'm biting. And but when it came to them 2 trees, she knows I was doing it. I've told her the last several years. Well, they'll maintain it. Well, I have. But it's down to them 2 trees where I gotta go around, and I am going on her property.
Did she not want you cutting the trees down?
They never said that. They said they have to maintain it, keep it maintained.
Did something happen there? I mean, it's alleged that she assaulted you that day.
Yes.
I'd like for you to explain to the court what happened.
Well, She's seen me clean several times, even on her property. But when I actually was cutting them trees down that I had to go around, they're trying to lift the road, I feel.
Well, what did she do to you?
Well, chainsaw wide open. As he came behind me, it's cold, and I had a jacket with a hoodie on it, and yanked it, and what are you doing the first time? And the second time she did the same time while I was chainsawing wide open. And first time when she told me to stop, she said she was going to call law. I said, go ahead, I think they need to be here. Well, and they came and he said he couldn't do nothing. It's an easement for her, both of us back off. So I went to the house, took a lunch break, kicked back a few hours. I continued, my job because that was my goals, I've been working on for 3 summers. Well, the second time, I took a little power nap and I come back down there. Here I go again. And I was chainsawing that one tree trying to finish it off, and I had that jacket and hoodie, yanked it and collared me and slung me around. And I was running that chainsaw wide open, and I stopped and cussed her out. I said, you hit me, I'll call.
Now tell me again, she grabbed your hoodie?
Slung me around.
Slung you around? Did she
My
hit
jacket,
you or anything?
it's fully zipped up.
Did she hit you or anything like that?
Yeah.
Well, explain what.
I mean, it wasn't hurting me, but it's physical. And I never called the sheriff either time. The second time, it's a gym out there on the other side. Some spectators witnessed it, and they called. I found out that somebody from the fire department witnessed it, and they called the sheriff. And
So there were 2 different times where she put hands on you that day?
Correct. I lived there all my life. It's my childhood home. They've been gone. They come in. They don't come to see me. I'm not blind. I don't know what I did to them. I complained a lot to them where they grass is up high, never mow it all summer. The weeds, sap trees growing everywhere outside the house. Her house.
And you tried
Now
to
she's back trying to fix the house up, which you let it go for so long. It's not livable. There's no gas, there's no water. She's living in it now. I can't see how. She's got another place to live.
So that house that you're talking about that your sister lives in was unoccupied for a long time?
Yeah, I grew up there.
No, but I mean, nobody's been living in it for a long time.
10 years.
When did she
Since my
move
mom
back?
passed away.
When did she move back?
Last year. Not even that, this summer. This summer, and then my brother pops in. And who's cleaning along the fence? Me. Who's doing all this, And I feel like they're trying to lift that road there because they're questioning me on it. I want to talk to my brother one time. He's seen him in 3 years. And I'm fed up with him. I mean, it really hurts me, it really does. What I did to him. They're pulling everything out from under me. They altered everything. The wheel and everything, second wheel. But my mom gave me my property ahead of time because I was raising the dog. Or I've been duped on that.
That's all I have, Your Honor.
Mr. Smith, you may cross examine.
So, I'm going to ask you some questions, Claude, and you can answer. And then Mr. Hill can ask a question if he wants to. I got some questions I want you to answer for me, okay? Is that fair?
Yes.
Okay. Well, you indicated you didn't suffer an injury, correct?
Didn't suffer no injury.
In fact, I think I wrote down, you said she wasn't hurting me.
Pardon?
You said she wasn't hurting me.
I wasn't. No, I mean, this girl.
Okay. And you say she slung you around?
I know the draw, the back of my hoodie, a good Carhartt jacket. And I was running a chainsaw wide open, my back turned, and next thing, wham, yank, and clobbered and swung around, I just let go of the chainsaw.
Okay.
You know, it quit.
Well, did you, or are you aware that she's the one who called the police in the morning with the Deputy Easterling? Showed up in the morning. Did you know that your sister called the sheriff?
The first time.
The first time.
To.
Okay, you didn't call the sheriff?
No.
She did?
Either time I did not call the sheriff.
Fair enough. When did you last use that right of way?
Pardon?
I said, when did you last use the right of way? It's got 90-foot
I
trees
use it
on it.
all the time. Both ways.
Okay, you have to go on her property to get around the trees because they're growing on the right of way line?
And I'm trying to make it right, because she's back there at the house, and I don't want no conflict with her.
But, so
And they questioned me this summer about it. I was out there working on the car, and, you know, come talking to me, he got the problems. I went down there to get a pack of cigarettes, and I come back, and they're by the fence. You know, like 2 peas in the pie.
May I approach Judge?
And, you know, you talk, I ain't sitting around.
Let me show you something. Maybe this will help with the question I'm asking. You actually go on her property because the right of way has giant trees on it, pine trees, correct?
Mm-hmm.
Is that a fair representation of the trees that I guess at one time were on there?
I've kind of,
I don't know if you've cut them
It
down.
looks good there, honest and ugly.
Is that her house right there, the house we're talking about?
And that's correct.
Okay, so that's your mom's house, where she's moved back into, was fixing up, correct?
Yeah,
Okay,
that's
so-
bad, I mean,
And these trees are in the right of way in this photograph.
I planted them long down there. We had
So
a
they're,
greenhouse business.
okay, and they're in the right of way, so you go around them with the grass to,
Yeah,
okay.
yeah. I can show you pictures on
I
my
would
place.
ask,
Can I show it, Roger? Can I show you pictures on my
hang on a second, let me,
What?
I gotta do some legal stuff here real quick. Judge, I asked for introduction, what I marked is, it's actually exhibit B, I'm gonna use the other today.
Defendants B.
Yes, and I'm going to clear this up with the living situation.
Any objection to defendants B?
I'm going backwards, I'm going to do A then.
Be admitted.
That's fine.
And I'm going to hand you what I will now mark, I should have done this the other way, Claude, I apologize, in this exhibit A. And ask if you can take a look and tell me, is that your truck in that photograph?
It's my truck.
Okay, and that's what we're talking about, where this alleged incident is near her house. Okay, Judge.
All right, okay. See, that's the same tree right here. I turned the other side away.
Okay.
Okay?
But that's the vicinity we're talking about.
That's only 12 foot back.
Understood. But close to her house is where this incident is supposed to have taken place, correct?
Yeah, right there.
Okay. And Judge, I'd ask for permission of defendant's exhibit A.
This tree right here, I got.
Okay.
Any objection?
No, Your Honor.
Be admitted.
Yeah, I can take pictures on my phone with a roll this.
I can see those, please.
Yes. I'm sorry, Judge.
I gave a lot of free cleanup on that one. You know.
And, you know, I understand you use, or have been.
Free cleanup. I didn't, you know, I could, took them silver for and charged them for what all I did.
Okay. Well, let me ask you a couple more questions, Claude, or Mr. Petty, rather. You have been using, you have a separate driveway or way to get into your residence, correct?
Correct. It's actually a little cemetery road.
Okay. So, and you indicated you were clearing the right-of-way to put in a trailer?
If I sell a piece of my property, yes.
Okay.
Whoever buys it, he'll have a right of way to come out of there. Yeah, I'm gonna keep it open. Because the cemetery road, I just can't take stock in certain things. They might put a gate there one day.
The deputy indicated you initially told him you did not want to pursue any charges. Do you recall telling him that?
Right.
Okay. And at some point, when she wouldn't agree to stay off the right-of-way, at that point you said, well, I want to press charges now.
Well, it was gonna take me to jail too.
Okay.
It was gonna take about, you know, I'm gonna continue what I was doing. I've been working on it for the last 3 summers.
Okay.
Trouble.
So you want, when the way I'm taking this, you want the deputy to intervene and make a decision on what I would say is a civil situation, but you said if she was not going to, this is what the deputy wrote, and correct me if I'm wrong.
Hold on a minute, my hearing's bad.
I'm sorry. I'm going to read you what the deputy wrote, and if I'm wrong, correct me or clear up the statement.
That wasn't that wrong.
Okay, but he wrote that if she was not going to stay off his, you call it, refer it as your property, and out of the easement so he could clear it, then he was filing charges.
Pardon?
So you said to something to the effect that you weren't interested in filing charges originally, even though you said she slung you around and didn't hurt you.
It's not right.
Okay, but you didn't want to
My
file.
property.
Okay, I understand.
You know
Well, I'm not trying to confuse you, Claude, just listen to my question. So you did make a statement to deputy, if she'll stay off the right of way, I'm not interested in pursuing charges. You did say that, correct?
Leave me alone.
That's what he wrote down. Okay, to leave me alone. And then at some point,
She was talking over top of me.
okay, I understand. But then at some point, you changed your mind and said, now I want to file charges. Is that correct?
It was going to take both of them to come back. I can't take stock now. You know, I know she was going to continue what she was doing.
I'm not hearing you very well.
She's not going to stop.
Okay, but you said about taking both of you to jail? What-
Yes.
The deputy says we'll take you both to jail?
Yes.
Okay. But you did not
go
go
ahead
to
and
jail?
take her my last statement.
You said go ahead and take her.
And she had a break. She said just went back in the house.
Okay.
I mean, it's my property, my easement. She knows it. There's something else trying to live off me.
Judge, I have no
It
further
took me out
questions.
of me.
Okay, thanks, Paul. I have no further questions, Judge.
Any redirect?
Yes, just one question, Your Honor. Claude, did you determine that she wasn't going to leave you alone, and so you needed to file the charges?
Correct.
That's all I have, Your Honor.
No recross based upon that
You may
question.
sit down, sir.
We rest, Your Honor.
There you go.
You're done. You can step down from the witness stand.
May I have just a minute, Judge? Tell the truth. Judge, you have to speak to my client. She would like to testify, so I call Ellen Rubel at this
All
time.
right, Dan, if you come up to the witness stand, I'll swear you in.
And Judge, while she's walking up, I will vouch to her. I did advise, she doesn't have to testify. She wants to testify in her defense. Hopefully clear this matter up.
And if you raise your right hand, I'll swear you in. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? You may be seated, ma'am. Mr. Smith.
Thank you, Judge. State your name for the record, please.
Mary Cecile Ellen Pater Rubel. I go by Ellen.
You go by Ellen, okay. And you are the brother to Claude Pater.
I am.
And we'd heard testimony, we're not going to go through it all, but your mother left you both some property, correct?
She, before she passed away, she deeded Claude half of her property, the other half to my older brother, my younger sister, and I.
So he got one half and you split the other half with your siblings?
Yes.
And is that the picture that's on the screen?
Yes.
Okay, and he would own the half to the left lower part of that picture, correct?
Yes.
And you and your siblings own the, I want to call it triangle, the top part of the
Yes.
property? Okay. And there has been testimony that Claude had discussed with you clearing that easement or right-of-way. Did you have such a conversation with Mr. Pater?
No. In July, when our older brother came to visit.
I'm sorry, 2023, this past July, or
This July.
July of last year now? Okay. Go ahead.
That was the first that we had heard that he might be selling a part of his property. But that was that was the only time we heard that.
So you didn't have a sit-down conversation with your brother Claude about?
We were outside, my older brother and I were outside near our property line, just reassessing, possibly resurveying our property.
Okay. And let's transition forward to October 15th of 2023. There was an incident that morning which prompted you to call the sheriff's department, correct?
Yes.
About what time of morning was that? Do you recall?
Probably about 9:30 or so, I heard a chainsaw. Sunday morning, I heard a chainsaw very close to the house. So I went to the front porch and looked out, and he was cutting all the branches off the 2 tall pine trees that were in the alleged right-of-way.
Let me ask you, did you speak to him, then call the sheriff? Did you speak to him at all, or
No,
just call the sheriff right away?
He came unannounced and started doing what he was. I was not aware that he was doing that.
Was he
planning or going to come by that morning or anything?
Fair to say it caught you by surprise.
It caught me by surprise, and yes.
Did you have a conversation with Claude when you heard the chainsaw went out and saw what it was?
I did go out, and I started to ask him why he was doing what he was doing, and he ignored me. He wouldn't answer. Just kept going. He was angry. He was mad.
Did he say why he was mad?
I would say.
Okay. So at some point, and I'm still not clear, did you call the sheriff after you talked to him? Were they on the way that you were talking?
I asked him to stop. I just, I asked him why he was doing what he was doing, that he was destroying everything, that we could talk. Let's talk about, what it is you're angry about. And he wouldn't, so I called the sheriff, and he came by, and...
Deputy Easterling?
Yes.
Okay. Different sheriff's deputy that we heard testify?
Different, yes.
Okay. What was the result, and I don't want you to what the deputy said, but did at some point the deputy leave and left you and Claude to go your own separate ways?
He did. I asked him if he could stop my brother from doing what he was doing. And my brother interrupted and said, it's my easement, it's my right of way, I have a right to do this. And so the officer said, is it true that this is his easement, this is his right of way? And I said, well, there is a right of way in his deed, but he has not used this right of way. And he said, well, if there's a legal right of way, I can't do anything. This is really a civil matter. And he said, I can't do anything anymore.
Okay, so then he left. So what happened then? Did you go back in the house? Did Claude take his lunch break like he testified?
I tried to talk to Claude. I tried to get him to stop.
Did he at some point leave or take a break after
He did
deputies?
take a break.
Okay.
Yeah, and then after he took all the branches off the taller pines there, he started towards the pecan tree. There's a pecan tree that's on the property line, and it's over 100 years old. And at that point, after the sheriff left, I understood that, okay, well, I suppose I can't do anything about what he's doing, since he does have a right-of-way. But I said to him, I said, please don't cut this pecan tree, Claude. I said, this is a tree that's over 100 years old. It's been on our property since we moved here in 1965. I said, it's on the property line. Don't touch that tree. You can go around this tree if you need to move your, get your 12-foot across over and out. And he left it alone. He did stop. There was a horizontal cut into the tree, which he started, but he stopped and he left and he went back to his place.
Something later on, well, let me ask this one. You say there was a horizontal cut into the tree. Did he at some point come back and finished cutting the tree?
He came back in the afternoon. I heard the chainsaw again. And it seemed as though his mission, his goal was to take the pecan tree down. So he was cutting the tree.
Well, you testified he made an initial cut, then he stopped.
He made an initial cut, but he left.
Approached the witness, Judge.
Yes.
Mark
Mark is C.
C, thank you, Judge. I'm going to hand you a photograph
Yes.
and ask, first of all, what is that? Looks like that picture.
That's the pecan tree, the
Who
100-year-old.
took that? Did you take that picture?
I took it, yes, right after he left that morning.
Does that truly and accurately depict the condition of the pecan tree right after Claude started cutting into it? Judge, I move for admission of defense exhibit C.
Any objection?
No objection, Your Honor.
So, and I think he testified also, he takes a break, goes, eats his lunch or whatever, he comes back.
I thought he was done for the day.
Okay, okay.
I just thought,
After you had the
He had made-
conversation with the deputy and then you went to back to the house, he leaves, you thought everything was done.
yes.
So is this around 2 o'clock or do you recall what time?
Probably around 2:30.
Okay, you hear the chainsaw again.
I heard a chainsaw again.
Okay, and what did you do when you heard the chainsaw 2:30 later that afternoon?
I looked out the window again, and I could see that he was back at it, and this time he went right to the pecan tree.
Did he ultimately take down the pecan tree?
Well, not while I was there. It was after I was taken away.
You said taken away, you were arrested and taken to jail?
He had it, yeah.
Well, let's talk about where he said you slung him around, you were hitting him. He said you weren't hurting him, but what do you recall as far as any physical violence, any attempt to hurt him? What happened?
My intention was to protect my property and protect the pecan tree.
Well, your statement that the deputy took, you wrote it yourself, said that you pushed him. Would
Yeah,
you describe to the judge what you meant by pushed him?
I first was calling his name, and he wouldn't turn his back towards me, wouldn't stop. And then I thought, well, maybe he doesn't hear me. So I walked up to him and I tapped him on his shoulder. And
You didn't sling him around?
he didn't turn around. He was ignoring me. And I kept calling him and tapping him, and he was going at that tree. And so I tried to get in between him and the tree. So I pulled him or pushed him or whatever. I grabbed his by the shoulder to try to get in between him and the tree. I was going to stand in front of the tree. He would have to cut through me to get. I just didn't want him to cut the tree down. But he was mad. He was on a mission.
Was your intent to cause him physical harm when you
No.
grabbed him to get in between him and the tree?
No, I wasn't. I couldn't understand why he was so angry that morning. He was very angry for some reason to come on a Sunday morning to do all this damage.
At some point, after what you just described, the deputy testified he showed up because he didn't see anything happen, but he shows up. Do you recall having a conversation with the deputy? You and Claude, I think, both talked to him. Okay, tell me what happened once the deputy arrived on scene.
While Claude was doing that, the second time, I started to call the sheriff. I don't know how to call the sheriff and have help again. And a sheriff pulled up, so obviously my call, somebody had already called the sheriff. And he came up and he said, I understand there's an altercation here. And he looked at me and he's talking on a phone and he's looking across the parking lot towards the road because there was a fire truck there. And he said, I understand you're the aggressor, ma'am. And I said, I am. Wow. Why do you think I'm the aggressor? He said, well, somebody there's a witness.
Did he tell you who the witness was?
He didn't tell me who or what. He said, and then he said, the fire department called. So,
What question did the deputy then ask you?
what question did he ask?
Yes. He told you why he was there. The fire
Yeah,
department had called
said,
it in.
What is the problem here? And I said, well, I asked my brother not to cut this pecan tree, and he's cutting the pecan tree. Can you help me? And,
What was your demeanor when you saw Claude cutting the pecan tree? Were you agitated, violent, upset, crying?
I was trying to protect the tree. I was not intentionally trying to hurt my brother. I just wanted to remove him from the tree. I wanted to get to the tree and protect the tree.
Put yourself between him and the tree.
Yes.
So, at some point, did he testified, he put you in the back of the patrol car
He
to
said,
talk to Claude, then talk to you? That happened?
He said, I'm going to take you down to my patrol car here, which was on the parking lot of the complex. He said, you can fill out your report. And he took my phone, and then he went up and he was talking to my brother. About 5-10 minutes later, he comes back down. I had finished my report, and he said, okay, so your brother's not going to press charges, but I'm going to take you, I want you to come up here with me, and I want you to talk to your brother. And he said, now, if you cause any trouble, I would take you to jail. If your brother causes trouble, I'm going to take him to jail. If you both cause trouble, I'll take both of you to jail, he said. So he took us, I said, I understand, officer, and I went up there, and we were just talking about the tree. I said, Claude, please don't cut the pecan tree. You can take your right away. You have 12 feet along my property line. Take it around this tree. It's on the property line.
And at some point, you were arrested.
At some point,
Do you know why you were arrested?
I don't know what my brother said to the officer. We were talking about, well, it was actually Claude that was doing all the talking. He was talking about an incident that happened years ago about the sheriff being called because he was on our property trying to take a piece of furniture out of the house that he said belonged to him, but it actually belonged to my older brother. And for some reason, in that conversation, the sheriff looked at him and said, so do you want to press charges then? And my brother said, well, I guess I do then. So he takes me up to the house. He said, I'm going to have you close up. I was kind of surprised that all of a sudden I'm now going, with him. And so I was walking up to the house, and I asked the officer, I said, officer, I said, do you suppose that when you asked my brother if he wanted to press charges, that he decided to press charges? And he was not happy with my question. I just asked a question, and then he told me he was going to read my rights and that I couldn't lock my house up. So I didn't get a chance to lock the house up at all. I walked back down to the patrol car and
Went to the county jail.
Mm-hmm.
You ever been in the county jail before?
No.
When you came back, what was the condition of the pecan tree?
It was gone.
This is my first witness. That's marked as Defendant's Exhibit D. Is that the condition you found in the pecan tree when you finally got out of jail? Did you take that photograph?
I did.
And your acronym depicts what the condition of the tree was in when you took it. Ask for admission of Defendant's Exhibit D, Judge.
Any objection?
No objection.
I have no further questions.
Submitted. Cross-examined.
Thank you, Your Honor. Ms. Rubel, the pecan tree was in the easement when your mother granted the easement, wasn't it?
It's actually on the property line.
But it's
Yeah,
partly in the easement.
I guess it's partly in the easement.
I mean, the easement's 12 feet wide.
Mhm.
And so the property line you're talking about would mean that if it's on the property line, then part of it's in the easement and part of it's out of the easement, on
That's
somebody
right.
else's property.
It is.
And trees have limbs that spread out, so if the limbs of the trees, the branches probably went all the way over the easement, right?
Well, it had been severely cut. The top of the tree was cut severely several years ago, but it had started to grow back. It was coming back to life, and it had several beautiful sprouts. It was just, it had a canopy. I have a picture of it where it shows the canopy of it.
If a person, if Claude Pater needed to use that easement, that 12-foot wide easement, which would be the only 12-foot wide entrance that he could have to his property, that tree would be in the way, wouldn't it?
Not necessarily. I'm sorry, but it is on the property line. And the other side of the property is a ditch, and then several feet after that is a parking lot for the complex.
Next door.
Next door, yes. So in order for, if he were to try to get to the driveway I have there, he could certainly go around, and that's what I talked to him that afternoon when the sheriff, the second sheriff stopped by, and he was there witnessing our conversation. I said, Claude, if you want, you could go around, you could take your 12-foot and go around this tree. I'll give you 12 foot onto my property. You'll take 12 foot to get around that tree. The other trees are indeed in the easement. They're tall, they're 80 feet tall. They've been there since before he got his property.
So you were suggesting to Claude that he could go onto your property to move something into his property?
To just move he has the 12 foot along the property line at the fence, but this tree is right at the driveway. So if you're looking at this diagram, and you see the right-of-way across the front, where it kind of angles is where the tree was, and that's where the driveway is.
Okay.
Right at the angle. So
that tree was there when your mother granted him the right-of-way across that property too?
Yeah, it's been there probably 100 years. It's an old tree.
You mentioned that you were talking with your brother about resurveying the property?
My older brother, yes.
What's wrong with the survey? Is there something that you think is in error about it?
Well, we couldn't find our survey. We had it surveyed in, last time we were up to the house together. We come just about every summer and do work on the house. We have a landscaper, guy that mows the grass every year since my mother died. And what we were going to do was, Claude has been using, there's a little square up there at the corner. It's on our property, my older brother, my sister. It's a shed, and he had tools in there, and we were thinking about resurveying it to give him that shed. Because he'd been using it for a long time.
Is that the shed that's shown, like a little square?
It's actually a concrete pad. It used to be a basketball court. You can't see the shed, but it is adjacent to that pad. It's right next to it. So, I believe Nemeth was our surveyor.
It says Jack Meenick.
I believe that's who it was.
The second time around when Deputy Orsbon responded to a call, this was a third party who saw something happen and made a report and said you were the aggressor.
That's right, that's what he said.
And there was enough to it that it caused apparently a
Well, he said-
volunteer fireman to call the sheriff about it, right?
Mhm. He said
That's
there
all
was
I
a
have.
scuffle.
That's all I have.
Anything else, Mr. Smith?
I do, Judge, as far as being the aggressor, you admit you put your hands to get between him and the tree, correct?
I did, I tried to get in between him and the tree to protect the tree.
Okay, and it's-
I had no intentions of hurting my brother, I just wanted to get to the tree.
And we don't
I'm
have
just
this,
trying to push him aside, and because I already asked him, please don't cut this tree down.
did you cause a physical injury?
I didn't see any, I didn't
you?
hit him.
He already said he wasn't injured, Mr. Smith.
Yeah, he wasn't injured.
He did say yes.
Yeah.
I have no more questions.
Anything else?
Nothing else.
Find the defendant not guilty.
Thank you, Judge.
Sorry, ma'am, you got it. This case is dismissed.
Appreciate it.
State of Ohio versus Bradley Hensley, case number CRB 2412.
All right, Mr. Hensley, do you have counsel representing you?
I'm going to be representing myself.
All right.
Your Honor, I spoke with Mr. Hensley the other day and offered that if he wanted to pay the court costs, we would agree to dismiss the charges as we did with the other fellow. That was
Is that something you're interested in?
Quite possibly.
Okay.
I do have a question.
I need to know now because we're ready for trial.
I have a quick question if I can.
Sure.
Would there be an easier way for me to get like a protective order on my daughter on them, or will I just have to go through this?
Oh, this really doesn't have anything to do with you getting a protection order.
Well, it would make me feel better because they showed up to the house 2 days ago before they left to go to Florida. And when they went to leave, they were shouting and yelling on the road, so I was just wondering.
Well, there's a procedure you can go through at the common police court to get a civil protection order.
Okay.
You can get counsel, but the case filed against you really doesn't have anything to do with that.
Are the charges going to be dropped, or will I be stuck with that misdemeanor?
We would agree to dismiss it if the court costs are paid.
Okay, that's fine with me.
All right, can you do that now, or you need time?
How much is it?
It'd be $110.
Yeah, I got it right now.
Okay, see the clerk and the case, and to the right, the case will be dismissed then.
All right,
On
thank
the
you.
payment of costs. Is that it?
As far as I know, that's it.
All right, court's adjourned.
Your Honor, we have a Shelby Rodriguez checking into the clerk's office. He said he had court today. I sent him to the clerk's office to check in.
He failed to appear today, yes.
Do you have a phone for him?
At one time I did, to be over here.
Still have that file right here. Open it. It's Shelby Rodriguez. I was
Yeah,
one.
you have it. You should have it out.
I can't get you on the phone. State of Ohio versus Shelby Rodriguez, case number CRB 23396, CRC 23816.
All right, this is Mr. Smith's this your case?
It is, Judge. It was a pretrial earlier. I had trouble. His phone has some type of block or something to get a hold of him, but he has gotten word of the pretrial. He showed up, albeit late, luckily before court adjourned. I think we just need to set a trial date. I don't know. We've had multiple trials.
Can I talk to you for a minute?
Yeah, hang on a second.
If it's going to get set for a trial, isn't it? It's going to have to do any jail time. Okay, is that under jail time? I just got it in place and then.
All right, we'll do it. I'll talk first. Judge, apparently there's going to be a change of plea. I talked to Mr. Heald. This is a charge as a first offense. I think he had one in Ironton, but they were simultaneous, so it wasn't really a second offense. So I understand the charge being a first offense, he would enter a change of plea to guilty to the first offense.
There's an endangering children charge also.
And we are willing, under the circumstances, to dismiss those charges upon his plea to the OVI.
All right, is there a recommended sentence?
It's he had one in Ironton that arose, I don't remember directly before or after one, but they were both pending at the same time. That case has been disposed of with a plea and I think that one involved alcohol. This one involved marijuana, and that was the only thing in the test on this one. So we don't have an opposition to, I don't know whether he's done the 3-day driving.
He's scheduled to, he hasn't done, but you are scheduled to do the 3-day school.
I think there needs perhaps to be a little bit more of a recognition that we do have a second one. We'd like to maybe, I don't know if he needs to have an assessment for some treatment of some sort, alcohol, and marijuana, drugs, and some community service. I don't know about the 3-day driving school because I think he may have already done it in the other case, but I guess he could do it again.
He has Ohio Medicaid, Your Honor.
Has he already been sentenced in the Iron Municipal case?
I believe he was scheduled to do the 3-day school in lieu of jail time. I think Judge Walter gives 10 days suspended to school, which you've not done yet. But you have scheduled.
Yes, with John Kincaid's helping me schedule it.
John Kincaid, the probation officer, is helping him get that done because we've lost our.
I don't think it makes sense to have to do it twice.
I agree.
I want to read Trooper Jewell's report. There were 6 children in the car.
Yes, Judge.
positive for THC metabolite only,
And over the per se level.
over the per se level.
Correct.
Well, one thing I want to make sure that he understands, if I accept his plea on this, he's now going to be at a second offense level on his driving record, so if he gets a future one, it's going to be a third offense, which has much more severe consequences.
Actually, it'd be a third, because he got
That's
the
what I
one.
said.
Yeah.
The next one would be third.
1 plus 1 equals 3. That, you understand, except if you get caught.
Yes, Your
again,
Honor. Yes, Your
it's
Honor.
And if you get caught in West Virginia, it's a felony.
Yes, Your Honor.
Okay.
All right, anything else?
I don't believe so, Judge, no, sir.
Anything you wish to say, Mr. Rodriguez?
No, Your Honor.
And you're living in Ironton?
Yes, Your Honor.
All right, so on the OBI, I'll impose a $600 fine. He pled guilty. And I'm making it a little higher because you had a prior, it's not a second offense, but it's a first with another first. So I'm going to impose a $600 fine because of that. Or you pay court costs. Be a 6-month license suspension starting today. Because he didn't have an automatic license suspension.
Correct.
I'm going to make it 30 days in jail, suspend 30. 60 hours of community service. And that's because of the other case. 2 years of well before probation. I'm going to require you to get an assessment for substance use issues.
Yes, sir.
I'm not going to require you to go to the
3-day school again,
intervention
okay. That's,
program, because
makes
I don't
sense.
think it makes sense to have you go to it twice.
I agree.
Why don't we, have you been to any kind of substance use treatment in the past?
Yes, Your Honor.
Where did you go?
Brightview Health, something or other in Portsmouth.
Okay.
Only because I pulled it up on Google, but I lived here in Ironton at the time.
Okay, I'm going to...
And I stopped going, I graduated and I stopped going, but
I'm going to, and you are living in Ironton. I'm going to direct that you go to either Amended Reads, or does the counseling center have a facility in Ironton?
They do, Your Honor.
Okay. Either Amended Reads or the counseling center, both are in Ironton. Those are either, one of those are acceptable.
To get an assessment.
For an assessment, and then you do whatever treatment they set up for you.
yes, sir.
Probation officer will talk to you about all this.
Yes, Your Honor.
I want you to be, you have to be honest about why you're there. You're there because you've had 2 OBIs within a fairly short period of time. I'll set his first review hearing for March the 15th.
No, so we can use it again. No, the one on, well, yeah, the one on.
Okay, was there any other charges? There was an A, B, and C, so there must be. What are the other traffic charges? Speed. Okay.
Speed, yes.
$40 fine on the speed. And what was the C? Lane violation, $10 fine on the and the CRB case number 23396 is dismissed at the motion of the state.
Thank you, Your Honor.
Meet with Mr. Major, who's in the back of the courtroom.
Just follow
And then
him.
you're free to go after that.
All right, what time is it? Oh, legal game, 9 o'clock.
Okay, see, driving privileges. You did have insurance, okay. I'll give you permit to drive for work, community service, to go to counseling, anything else you need driving privileges.
Is that it? Thank you.
Yes, Your Honor, thank you.
Is that it? Okay.
That's it, Judge.
Mr. Major will take care of that.
You need to follow right there.
Court's adjourned.
Listen, worry. All right.